In a matter, I had filed a writ appeal number 769. 3 weeks' time was granted to cure the defects. It was cured, but with some lapses on the part of registry, it could not, it was placed and it is for default. So I filed the restoration application that should be listed on tomorrow. I will request to list that application tomorrow.
IA is filed.
IA restoration.
Monday.
My lord, serial number 48, my lord. I pay for the respondent number 3 and 4.
Near mic.
My lord. Serial number 48, my lord. I pay for respondent number 3 and 4. I seek 2 weeks adjournment, my lord.
48.
Arguing counsel, Mr. Bipin Hegde is not keeping well, my lord. 48, my lord.
You want time?
Yes, my lord. Respondent number 3 and 4.
The request of learned advocate, Mr.
Bipin Hegde is arguing counsel in
For the respondents, 10 or to 4th of September.
Much obliged, my lord.
My lord,
Yes.
Madam, moving this memo contempt petition, my lord, despite the order has been passed on 12/3/24, ad interim order has been passed, but still the respondent is trying to evict the petitioners and they're trying to demolish the house, my lord. So I'm moving the memo to file the contempt.
Listed on 21st August.
I request on behalf.
If you don't file memo, it will be listed earlier. So don't file memo. Don't accept it. Yes.
Oh my, 21st August.
21st August. Only 21st August. Yes.
Serial number 12, my lord.
12.
12, my lord.
Yeah.
The KADB, respondent KADB, I filed one more appeal, my lord. Post along with this appeal, my lord, 1005 of 2024, writ appeal.
I appear for the respondent, my lord. Even we have
What is to be done in 12?
Pardon?
What is the request?
Yeah, post along with this appeal, my lord, 1005. One more appeal filed by the KADB, my lord. Post along with this appeal, my lord.
One more appeal is filed.
Please,
So to be listed.
very
with
same impugn,
12 to be listed with the appeal number
1005 of 24, my lord.
1005
Of
of
please.
2024 on
Start date
20
may be given, my lord.
on 23rd August.
Start date may be first week of, there is an urgency, my lord.
What is the argument?
That's why the illegal allotment, KDB has illegally allotted to the,
Then wait, it is called out. You are saying that to be heard with some other.
sorry,
What do you want? You want to,
so start date,
for calling it out, or you want the adjournment to be listed with the room?
start date may be given, any start date may be given, my lord.
A short date will not be possible. Short date will be 21st August.
Please.
PAL matters, my lord. One matter, my lord. There is an encroachment of Bidar Fort, your lordship. Ancient monument area, my lord, which was now cleared. It was, they submitted a report, your lordship, compliance report. That may be taken, my lord.
It will be listed. It
It is not
date
listed.
is given.
It is a matter of 2021, your lordship. That is the reason, your lordship.
The
Now
advocate
they have submitted.
Learned advocate general is appearing. Same matter?
No, it is a different matter, your lordship.
Different matter, then date must have been given.
No, in this, no, it has not yet come up before the court, my lord, after the order has been passed, your lordship. That's the reason.
It will go to then 18th of September,
18th. Compliance report as they have.
whatever.
And one more matter, my lord.
18th September.
One more matter, I'm sorry, one more PAL matter, my lord. The CS sites, my lord, which has been allotted in favor of the third respondent, third parties, your lordship. They are constructing the building, your lordship. We filed a writ petition and notice has been ordered, your lordship. In spite of service of notice, your lordship, they are going on with the matter, your lordship. That's the reason one matter may be taken.
File
CS sites, my lord, is a meant for public purpose, which has been used for now individual purposes, your lord.
File IA.
Yeah, my lord. Yes, your lord. Great.
Serial number 50, my lords, appearing for the complainant. Requesting for the, appearing for the complainant, my lord.
Serial number
50, my lord.
50.
Yes, ma'am.
What do you want?
Requesting for the withdrawal of the case, my lord.
Withdrawal.
Withdrawal is.
50. Learned advocate Mr. Giri Kumar.
Yes.
SV. Seeks permission to withdraw the present contempt petition. Permission is granted. Dismissed as withdrawn. Upon instructions of the
Lordship
complaint.
moving a memo for posting in a contempt petition wherein the respondent State Bar Council is refusing to enroll the petitioners despite interim order by this honorable court. This is urgent, your lordships, because the Bar Council, the All India Bar exam is approaching soon. And also, only yesterday, there's been a Supreme Court decision again charging exorbitant
It's
fee.
a different.
No, your lordships, the writ petition,
When the exam is going? to be?
in the coming month, your lordship,
Coming
in
month.
August. Could, and also they've applied for a stipend that's available for law graduates.
13th August.
A little earlier, lordships, please, because the last date for them to apply for the stipend is today. And without enrollment, they won't be able to avail it.
13th August is not far away.
Anytime, but 5th August, your lordship. 5th August, your lordships, in the first week.
5th, not 13th. Yes.
Your Honor, for cause list number 76. With reference to annexure B, the orders issued by this honorable court, I request that the honorable court grant interim relief orders for prayer points P to DD in the writ appeal today, Your Honor. With reference to the annexure B, the orders issued by this honorable court, I am here to receive interim relief orders for prayer points P to DD in the writ appeal. I would need under 10 minutes to walk through the prayer points and then receive the interim relief orders here.
Very well. Whatever you want to argue when it reaches.
Your Honor,
Whenever whenever the case reaches, you argue whatever you want to argue.
I'm not here to argue. There is nothing to argue.
Nothing to argue.
No.
Then don't mention, it's nothing to argue. Withdraw it, the petition. Withdrawing the petition.
No, the orders, annexure B, the court has recognized.
Whatever you want to say, not now, when it is called out.
Yeah, Your Honor, the urgency in the matter is that in annexure B, the orders issued by this honorable court, the court has given the respondent 6 months to take the necessary action and issue the consent letter, Your Honor. Now, these interim prayer points that I'm requesting, also the honorable court might give few weeks or few months for the respondent.
You may
And hence
request
there
when
is
it
urgency
called.
to issue the orders for the interim prayer relief.
You may request when it is taken up.
So this afternoon, it is listed.
Whenever it reaches. We are
you-
here till 5 o'clock.
Your Honor, since I'm a party in person, sometimes the arguments in this honorable court go on for hours. If you give me a specific time, I would present the.
Not possible to give specific time. Whole day is available for us and for you.
So,
Priority to be given to any matter in that way.
uh,
It is already listed today and it will be taken up if it reaches.
Okay.
Yes.
With Lordships kindly,
First pronouncement, then serial 6.
with Lordship kindly. Serial number 4, my lords, serial number 4.
Serial number 4.
Yes, my lords. I underwent a cataract operation, my lord. Kindly have it next week, my lords.
22nd of August, serial number 4.
Oblige, my lords.
Yes.
My lordship, serial number 8 and 9, my lordship. I'm for the appellant. Serial number 8 and 9, my lordship.
8 and 9.
8 and
Yes.
I'm for the appellant in this matter, my lordship. Senior counsel is engaged in this matter. He's unwell, my lordship. Kindly have, he's unwell, my lordship. Kindly have this next week, any date, my lord.
23rd August. Both. Yes.
List number 1, pronouncement of judgment. Serial number 1, Mansi Kumar.
For the appellant, your lordship.
Writ appeal number 242, writ appeal number 366 of 24 are allowed. Writ appeal craft 2 of 24 is dismissed. Order of the learned single judge in WP 15859 of 21 and WP 15590 of 21 dated 10/1/24 is hereby set aside. The writ petitions are also dismissed.
Obliged, your lordship.
List number 1, serial number 6,
Not 3, 6.
Chidanandaya.
6.
Serial number 6,
May it please your lordships.
Ellam Chidanandaya.
Oh, my phone is there. I don't mind shifting it this side, but
So there will be common order in petition number 1983 and IA number 7 of 24 in 1983, both same. Who appears for the petitioner in 19835? You are appear
I appear for the petition.
or learned advocate, Mr. So and so for the petitioner from learned and learned who appears?
I appear.
Government advocate, Mr. Mahindra for the respondent. And anybody?
Amicus curiae appointed.
Sri Aditya Sondi amicus.
I appear as the amicus.
And learned government advocate, Mr. S. Mahindra, full stop. Learned senior advocate, Mr. Aditya. Sondi, Tangi, what is it?
Sondi.
Sondi.
Who is amicus curiae, assisted the court. There will be order in petition number 1983. The operations of the query of the petitioner were ordered to be stopped by office memorandum dated 15/5/23. It led the petitioner to approach this court by filing this aforementioned writ petition. The office memorandum provided that in the receipt of the trial blasting report, the land cannot be used for any non-agricultural purpose, including for quarry operation. The setting up of and the operation of quarry leases within the 20 kilometers of periphery of the Krishna Sagar Dam was not permitted by the authority to ensure the safety of the dam from a state level Dam Safety Committee was constituted from allied as respondent 5 hearing, from which committee is switched off and has been considering the entire controversy. Pursuant to the directions issued by the court in earlier order dated 8/1/2024. By the said order dated 8/1/24. The present writ petition was treated by the court to be the public interest petition. Paragraph. The Dam Safety Committee been examining the issues involved in respect of the controversy, as well as its related aspects. It was recorded that the committee had given a hearing to the interested parties and has been dealing with the cases involving such controversy. In paragraph 8 of the order dated 5/3/24, it was observed by the court that granting of time was necessary to the committee to show that to enable to enable the committee to complete the proceedings. So directed the entire exercise shall be considered, shall be completed within 10 weeks, and the report shall be submitted to the court.
5/3/24 that.
The report is awaited. The report of the committee is awaited. It was paragraph further observed that there's further, there were certain applicants who want to implead in the present proceedings. In that regard, it was observed in the order dated 5/3/24 that should be open for them, for such interested impleading applicants to approach this 1/5 committee to put up their case and the grievance, which shall be considered by the committee. Today, when the paragraph. Proceedings come up for consideration before the court. Learned government advocate produced along with memo dated 30/7/24. The minutes of the proceedings of the third meeting of the Dam Safety Committee held on 12/7/2024. The minutes records the steps taken and proposed to be taken in respect of the Krishna Sagar dam issues by the committee. Not the learned government advocate took the court through the contents of the meeting, minutes, contents of the minutes. Paragraph. What is to be noticed is that from the committee in the past, of its report has noted that connection with the issue involved, certain individual representations were received. Where the permission to carry on the mining operations were sought for. Having noted about the said representations, the committee observed thus page 29. प्रोफेसर मधु शेखर, वहां से स्टार्ट करते हैं। प्रोफेसर मधु शेखर। Again Madhu Shekhar. Thus, the committee took the view that since the present proceedings are pending, the representations of the private parties could not be considered. It is to be observed and clarified further in the above regard that the tendency of the present petition shall not in any way come in way for the committee to deal with and decide the individual representations which may be received by the committee. On the contrary, the committee is expected to go into the individual cases and take its own decision to be intimated to the court. An order dated paragraph 28th March 2024, passed by the division bench of this court in Sri Mancha Devi Stone Crushing versus State of Karnataka, is brought to the notice of the committee, in which also the court has made observations and required the committee to take into consideration the various aspects which may be raised by the private party and take its decision. Full stop. It is again clarified that if any individual case or application is put forward with committee shall go into the facts of such case individually and take its decision. Such decision, however, shall be placed on record of the present proceedings, before it could take effect. The decision which may be taken by the committee in respect of individual cases shall take effect only after approval of this court. With above clarification, the proceedings are adjourned to which date? September, October?
One more aspect of the matter. Now, the committee is contemplating to conduct analysis through mathematical modeling and proper validation instead of conducting trial blast. For which a timeline may be fixed, around 4 months time may be granted to conduct.
Learned government advocate invited attention of the court to the contents of the minutes of the
Page number 28.
dated 12/7/24, above referred, to highlight that the committee has now decided to undertake the which kind of operation?
Analysis through mathematical modeling and proper validation.
Has decided to underwent the detailed analysis through mathematical modeling and proper validation. So this is a scientific method, it was submitted and shall be adverted to instead of blasting.
Trial blasting.
Trial blasting, instead of trial blasting, full stop. It is for the committee to adopt the appropriate method to investigate and decide on the issue, to come to an appropriate conclusion about the safety of the dams. However, it is necessary to provide the time limit within which the aforesaid method is applied and completed, and the process is completed. The committee shall have 3 months time,
4 months.
4 months time to complete the appropriate process. Also, the present proceedings shall stand adjourned to 14th October. On which
Clear.
progress,
4 months.
4 months.
but on that day, the progress
Yes.
may be reported to by the, may be reported to by the, by learned government advocate. The progress may be reported to the court by learned government advocate. Now there will be an order in IA number 7 of IA number 7 of 24.
Yes, 7 of 20.
What is 6, IA 6? What is pleading?
Impleading.
Pleading. Impleading may be permitted, but you go before the committee.
Yes.
All the impleading applications.
And
The
the
lords
IA,
have passed an order on 2 hearings back saying that all the impleading applicants should approach the committee. And the committee should take a decision and.
Lad, he is not a party, my lad. I do not know how can he submit, my
So order in IA number 6 of 24.
Insofar as
Interim application is filed by one Srimati D. Vasantha, who seeks to be impleaded as party respondent for the present proceedings.
Supreme Court order.
The case paragraph of the proposed party is that she was granted pouring lease for black granite over 0.22 acres of land in survey number 200, Rachahalli village, KR Nagar Taluka, Mysore district, for 20 years, with effect from 23/5/26. It is the case of the applicant that it does not employ the use of explosives in its pouring operations and strictly adopts non-blasting methods for cutting the blocks.
ನೀವು 2 ಕಡೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ ಅಲ್ಲೂ ಹಾಕಿದ್ದೀರಿ
It is contended in the application that in view of the order dated 8/1/24 and the subsequent orders passed by this court in the present proceedings, she is not permitted to continue the pouring operations and that the orders operate prejudicial to her and that she is interested party. She is interested party in the outcome of the proceedings. Therefore, the impleadment rate for post office. As already noted above, the Dam Safety Committee is functional and this court has required the committee to go into the cases, individual cases and address the grievances of the individuals. Full stop. It will be open for the proposed applicant in this application to approach Dam Safety State level Dam Safety Committee with approved application. If such application is made, the dam safety committee shall go into it and decide strictly in accordance with the law. The decision shall be placed before this court in the present proceedings for the purpose of approval. If it is in favor of the, it shall be placed on record of the court, that's all. Before it could be implemented in favor of the applicant. Now, an order in IA number 7.
In 7, 6 and 7.
Heard for IA number 6, heard learned with respect to parties.
Sorry for the interruption, Mala. IA number 6 and 7 is filed pursuant to the observation made by the Honorable Supreme Court. So, yesterday, senior counsel has argued that, and your
So we are passing the order.
Yes. It's not, that's all.
If you want to
I want
improvise,
to just bring it to the notice of court.
no, don't interrupt when the orders are passed.
I'm sorry.
You can tell after the order is completed. It is a standing instruction to all the advocates that they are not supposed to interrupt when the orders are passed.
Apology.
We are in completely command with the facts of the case. And we don't invite any suggestions about language and the directions. It is our order to be our order. So please don't interrupt. It breaks the chain of the thinking. Please sit down. All may sit down. A number 7 of 24. Heard learned senior advocate Mr. Nagananda, assisted by learned advocate so for the applicant, and learned government advocate Mr. Mahindra for the respondents. The present IA is filed in the proceedings of writ petition number 19835 of 23, in which the prayer is to clarify the interim order dated 8/1/24 passed in the present proceedings to the effect that the said order does not apply to the entities which are engaged in quarrying and crushing activities using non-blasting methods. In order dated 8/1/24, passed by the court in the present proceedings, some of the following directions was issued. So it is green, all mining activities on all mining license, is able to find out. Why two applications are filed by the same party? Why two applications are filed by two same party?
One is for
The
clarification.
present, the applicant herein is the very applicant who has filed the interim election 6 of 24. In this application, while seeking the clarification with regard to the order dated 8/1/24, it is stated that in light of and pursuant to order dated 8/1/24 in the present proceedings, the Department of Mines and Geology received notice dated 19/1/24 to the applicant, calling upon the applicant to stop boring activities in the leased area and also to stop transportation of the quarried granite blocks against the said order of stoppage, the applicant had preferred writ petition number 3339 of 24. Which petition came to be disposed of by order dated 2/4/24 in lines of the orders dated, in lines of the directions passed in order dated 8/1/24. It is stated that thereafter the applicant approached Honorable Supreme Court by filing SLP interpret C number 11173 of 24, which was withdrawn as per order dated 17/5/24. Whereas the order of the Supreme Court reads as under, then quote the order. It is in view of the above order, it was stated that the present impleading application as well as the application for impleading application as well as the present application for clarification is filed. As stated above, the case is that the applicant is not using the blasting method, but uses the wire saws, SAW, and silent breaking powder. Therefore, according to the submission of the applicant, the order dated 8/1/24 may not apply to the applicant in carrying out the quarry operations. Court is of the view that order dated 8/1/24 is not required to be clarified. It is clear in itself. Not only that, in view of the order passed herein above in the main proceedings, as well as in the interim application number 6 of 24, it is always open to the applicant to approach the state level dam safety committee with a grievance which is sought to be, with a prayer which is sought to be made before this court in the present application. Full stop. It is for the state level safety committee to, dam safety committee to examine the case of the petitioner and take appropriate, this is strictly in accordance with law and on merits to be placed on the record of this.
One submission. One submission. In the beginning, your lordship was pleased to record that in the very first petition, we have not stopped the quarry or this thing. The grievance of the petitioner is non-conversion of land under 95(9).
In which matter?
In the first matter.
First matter.
First matter.
Oh,
To that text.
in the main matter.
In the main.
Lordship permission.
Yes.
Number 2 and 3.
Pardon?
IA number 2 is also for impleading.
2 and 3 is for,
Okay, 3 is for modification.
for modification.
Modification of the
A
order.
different part. Different part.
A different part.
Different part. Different party.
Yes, ma'am. Different part.
We'll dispose of the I all in the bottoms. So 6 below at the end of the present I disposed in the in terms of the order. Then 7 also same. And now order in IA number
2 is for impleading and 3 is for modification.
that 1 of 4 of 24. 4 of 24
4 of 24 is filed by
and
me.
5 of 24.
Yes.
So 1 is also there.
But
It
in
is
fact,
on,
IA number, first IA number 1, I have IA number, order in IA number 2 of 24. As well as IA number 3 of 24. Heard learned data with respect to parties. This, the IA number 3 of 2 of 24 is for impleadment. And IA number 3 of 24 is for modification of order dated 8/1/24, passed in the main proceedings. Full stop. Both the above IAs are disposed of in terms of the orders passed in IA number 6 of 24 and IA number 7 of 24 herein above. All the observations and directions passed in the said orders shall apply to the present applicants also. Both the IAs are accordingly disposed of. Then IA number, order in IA number 4 of 24 and IA number 5 of 24. Of the same identity.
Grateful.
List number 2, serial number 1, Mallayya MR.
may not appear for the petitioner.
For respondent 1, 2, 3.
May not petitioner secure 74% in 12th standard and apply for NEET PG, UG, sorry. So after applying, my lord, she, for utter shock and surprise, she is not included in the PWD reservation quota. And in the eligibility list, she is.
You have not mentioned the extent of disability. You have not mentioned the extent of your disability.
45%, my lord, 45%.
Where it is stated?
In the annexure A, disability certificate.
Annexure A it is.
Page number 11 and 12, my lord.
Yes. Locomotive,
Yes,
locomotive.
yes, my lord.
Yesterday you relied on that medical.
Yes, sir.
notification.
But in this, whether he has gone before the board of Karnataka Examination Authority, I do not know.
After the
He is asking for two prayers. One is, my lord, to the central government also. All India quota seats.
He wants the admission in MBBS course in any of its associate college, or either fifth respondent or fifth respondent is what?
KEM.
Karnataka exam. Authority.
Whether he has gone before the board or not, we do not know. My lord. I'll take instructions.
Yes, my
Don't
lord.
have the benefit of the notice has not been ordered to me yet.
Pardon?
Notice had not been ordered to me.
That will
yet.
issue notice written.
Yes.
Notice written never long.
My lord.
When?
Tomorrow, my lord.
13th of August.
Great, my lord.
Are you waiving? Accepting? Or?
Yes, I'll
And
take.
Advocate Mr. Ramesh accepts notice on behalf of Respondent 5. You are also accepting?
Lord, I appeal for the state, I'll accept notice.
Separately, learned advocate, learned additional government advocate, Mr. So and so. What is your name?
Sudev Hegde.
Sudhir?
Sudev Hegde.
Sudev Singh.
Hegde.
Accepts notice on behalf of the respondent state and its authorities.
Great, my lord.
Serial number 2, Ajay Kumar Patil.
Hearing, my lord, for the petitioner.
That
This is the matter relating to, my lord, they said
cabinet
that some
committee. is considered-
subcommittee is seized of the matter. Therefore, they had requested for time.
I must apologize, my lord.
What is the development?
There's not been much development on that, my lord. I'll not seek further time. We'll go ahead with the matter. We'll go ahead with the matter.
No decision has been.
No decision has been taken as yet.
When the counseling begins, process begins.
Counseling, my lord, schedule has not, in any event, my lord, by next week, my lord, we'll start the process.
May I make one submission? All India Counseling has already been notified yesterday.
Now, once the All India counseling process starts,
This
then
is not,
thereafter it's only a question of time, maybe a week or so.
this is not PIL.
This is not PIL. This is not PIL. That was a different matter, my lord.
This is that,
Hyderabad,
Hyderabad,
Karnataka.
Karnataka.
Hyderabad, Karnataka.
370.
Reservation under 371.
Not reservation. Again, my lord, I would like to reiterate, that would be an incorrect submission to say that I am asking for reservation.
So you are overseas citizen.
I am overseas citizen. I am overseas citizen of India.
So what you are
My
saying?
lords have passed an interim order in the next matter also. 3 submissions which I would just like to make, my lord, if my lord permits. First one is, my lord, as far as overseas citizens of India are concerned, there is unanimity, my lord, amongst even the state government, the KEA, they have stated so in their statement of objections also, that we have to be treated on par with the Indian citizens, at par. So first aspect of the matter, my lord, is that there is no dispute about it at all. Now, once, my lord, it is directed or it is held that we have to be treated on par with the Indian citizens, we merge with that class. So we have to be treated as citizens of India. This is my first submission, my lord. As second one, my lord, what is the extent to which we have to get the seats, or which are the seats that we are entitled to? Once it has been directed by the apex court, as also this honorable court, that we have to be treated on par with Indian citizens. Even on this second aspect, my lord, my respectful submission is, there is no dispute that we are entitled to the general seats. Kindly turn to, my lord, I have produced a series of interim orders which were passed by the apex court. And there is no dispute at all. May I request my lords to kindly turn to page 83 at annexure M. Page 83. This is the first of the interim orders, my lord. Though it does give some clarity as to which are the seats that we are entitled to. May I read from page 84 or not? The application for permission to add applicants as petitioner so and so is allowed. Having heard learned senior counsel for the petitioner and so learned additional solicitor general for the respondent Union of India, we are of the view that at least for the academic year, that is 21-22, respondents have to consider allotment of seats to the petitioners to pursue MBBS courses in medical colleges, which seats overseas citizen of India were eligible for before issuance of the impugned notification dated 4th March 2021, subject to their eligibility. Therefore, we direct the respondent National Testing Agency to declare the results of the examination. That is
Once. But are you apprehending that this page 84 direction will be not complied with by the state?
It has been complied with by everybody.
So
It
then
has
what?
been. But here, my lord, what I wanted to point out, my lord, here Supreme Court has clarified, as also the division bench of this honorable court has clarified, that while considering their cases for counseling on par with Indian citizens, they have to be considered for the under the general category or the open category. This is being complied by, this is the second aspect of the matter. First is we are being treated on par with Indian citizens. While being treated on par with Indian citizens, we are to be considered for seats only in the general category or in the open category, not for the reserved seats. Kindly turn to their own objections which they have fought.
So you
As far as these two aspects, there is no dispute.
You want your category to be reserved category?
No, I don't want it to be reserved. My respectful submission is, there is, my lord, what is known as in Karnataka, this is a special situation in Karnataka, where seats are, my lord, a regional representation is given to students or to the people of an area which is now known as Kalyan, Karnataka. Formerly it was known as Hyderabad, Karnataka. 7 districts of this state.
Constitution. Constitution. It has to be by law.
By law, and I have passed on the.
Where is that law?
I have passed on my on the previous occasion. I have given the, I'll maybe in the file, my lord, the Karnataka Educational Institutions Regulation of Admission in the Hyderabad, Karnataka Region Order 2010-13, which I had given last time, but I'll pass on one more.
Translated copy.
Translated copy. English. I have the English version. They have produced the Kannada version.
English version.
English version. May I submit, my lord?
J. 371J.
371J. Please, my lord.
There must be
Special
no-
provisions with respect to state of Karnataka.
Has to be a presidential order.
There is, my lord. I have given that on the previous, I am passed on one.
So where is such legislation or order which gives you the right to be considered as a reserved category on the basis of your domicile in Karnataka?
Yes, clause 4 of that order. Clause 4 of that order gives me the right.
Let us. Where is that?
Please, my lord. It is there in the file, but otherwise I'll pass on 2 more copies. I'm sorry. They have produced the Kannada version, but I am giving the English version of it. By law, it is by law. Domicile. Clause 4 of that, my lord. This is a presidential order. A candidate for admission, may I read, my lord, a candidate for admission to any course of study shall be regarded as a local person in relation to the local area. If he is born, this may not be relevant as far as we are concerned, my lord. B and C both are relevant, but I am relying on both these clauses. B, in case where a minimum educational qualification has been prescribed for admission, I am seeking admission to the MBBS course, my lord. There a minimum educational qualification of pass either in the 12th standard or 6 in PUC is prescribed. If he has studied in an educational institution in such local area for a period of not less than 10 consecutive academic years, ending with the academic year in which he appeared, or as the case may be, first appeared for the relevant qualifying examination, or where during the whole or any part of the 10 consecutive academic years, ending with the academic year in which he appeared, or as the case may be, first appeared for the relevant qualifying examination, he has not studied in any educational institution, if he has resided in that local area for a period of not less than 10 years, immediately preceding the date of commencement of the qualifying examination in which he appeared, or as the case may be, first appeared. Clause 3 also is relevant, man. Where either of his parents has studied in an educational institution in such local area for a period of 10 consecutive academic years. On facts, my lord, I would like to clarify, I am here in Karnataka. The petitioner herself, she has studied in that area. Not only has she studied, even her parents have studied for 15 academic years. My father was born, brought up. It is not as if I am in US or UK or some other foreign country, and then sitting there, I am seeking for admission under this category. On facts, my lord, my clarification is, I have also studied It does give, my lord. It does give. Clause 6. Clause 6. Six and 7. May I read, my lord? Reservation in regional universities and educational institutions. Yes. 371J. 70% of the seats. Yes. Yes. Please, in that construct is yes, absolutely, my lord. There clause 6. Clause 6. Clause 6 and clause 7, both. Reservation in regional universities and educational institutions, admission to 70% of the available seats in every course of study in any regional university or
No, this is not being followed, because this is below the, of course, government has to say on this. This 371J is a reservation meant for Indian citizens. That is not meant for Indian citizens, not for the foreigners. No, this has not been followed. That is why he has come before the court. That's why he has come before the court.
They are following this. They are following this only for Indian citizens.
They are following not for other than in OCIs. That other students we are following. Yes, yes, yes.
Very much.
Not for. Is this a reservation? Yes.
Yes, that is all. That is all. Absolutely, my lord. Precisely. That is my.
That's it.
If it applies to OCI card. Please, my lords. Please, my lords. That is what that is what I'm answering. That is what I'll answer. That is the third aspect, my lord. First aspect, as I submitted, we should be treated on par with Indian citizens. Second aspect, my lord, is while being treated on par with Indian citizens, we are only entitled to general seats. Third aspect, my lord, is how this applies. Hyderabad, Karnataka applies to me. How it applies to me. One reasoning, my lord, or one legal backing, which is the right that I have, is that I am a local person. I have studied there. My parents have studied there. First. There is, my there within that also, I have filed the IA. Please. Yes. Kindly see my IA, my lord, which I have filed. They have filed.
I have filed.
Both have filed. State has also filed.
State is also filed.
Government has also, KE has also filed. They did not dispute the first two aspects. They admit it. My lords. One is, may I request my lords to turn to the statement of objections filed by the second respondent.
I have filed it on 5th of July, my lord. 5th of July. My role is very limited as far as my lord. Nevertheless, I have touched upon the thing.
Paragraph 2, if I may read. Paragraph 2 of that objections.
Yeah, I have filed.
Government also has filed.
Yeah.
Paragraph 2 of the objections, ma'am. May I just read? KA. Paragraph 2. May I read from paragraph 2 onwards? My lord permits. At the outset, it is submitted that the rights of the OCI PIO card holders to be considered for admission to professional courses on par with Indian citizens in no more res integra. The issue is now covered by the judgment of the Apex Court rendered in WP number so and so and other connected WPs, Anushka Renguntavar and others. my lords.
He's reading my statement of
Second
objection,
respondent by KEA.
page
From
2,
paragraph
para
2 onwards. 2 onwards. At the outset, my lord gets it, my lord. At the outset, it is submitted that the rights of the OCI PIO card holders to be considered for admission to professional courses on par with Indian citizens is no more res integra. The issue is now covered by the judgment of the apex court rendered in WP so and so and other connected WPs Anushka Renguntavar versus and others versus Union of India and others, disposed of on 3/2/23, produced at Annexure N. This respondent, in obedience of the dictum of the apex court, has allowed all OCI card holders to appear for the CET and also allowed them to register for allotment of suit through counseling for the professional courses. Hence, the grievance of the petitioner to this extent does not merit consideration. It is relevant to mention here that after the rendering of the judgment, so and other connected WPs, Rule 5 of the Karnataka selection of candidates for admission to government seats in professional educational institution schools has not been amended by the state government to suitably modify the same to bring in the provisions in consonance with the apex court judgment regarding the admission of OCI PIO students. In this regard, the respondents also addressed a communication to the state government since the information bulletin had to be printed in anticipation of the directions in this regard from the government. In the notification dated 9/1/2024, in the eligibility clause, it is mentioned that the eligibility of OCI PIO candidates for government seats shall be as per the directions of the government. Nevertheless, this respondent will allot government seats. My lord, my emphasis is on this, my lord. Kindly note, will allot government seats to OCI PIO candidates as was being allotted in the earlier years as per the judgment of the apex court referred to supra. So there is absolutely no doubt, my lord, either in the minds of the KEA or in the mind of the government or as far as the contention of the petition is, we are entitled to the government seats.
Next.
Straight away.
Not reservation.
My further submission, my lord.
Yes.
Yes. Yes, that is the issue, well. That is the issue. Yes. Not with, that is what they are saying. I am saying I get it within that quota. That is my submission. No, I have to still address my arguments on that issue, whether I am entitled to that quota. Government seats, I am entitled to. All colleges in Karnataka, government colleges, medical colleges in Karnataka, any general category seat, I am entitled to. And in the private colleges also, 40% of the seats in all private colleges are reserved as government seats, where again, there is a reservation policy which is being followed. In that 40%, 20% is for reserved candidates, and the 20% is for the open or the general candidates. There also they will consider me. If my understanding of what they have said here is correct, 100% of the seats in all government colleges and 20% of the seats in private medical colleges, which is reserved for the open category. These seats I am entitled to. Now, within that 100% seats in the government medical colleges and the 20 at par,
Not as.
at par. My lords, with
Yes.
citizens, par with citizens. Yes, those seats I am entitled. In addition, going one step ahead, that is my submission. Lord. Now, in these 100% general category seats and the 20% in the private medical colleges, in each college, there is a Hyderabad, Karnataka open category seat or a general category seat. Each college, I have produced the seat matrix. They have themselves said Hyderabad, Karnataka general, Hyderabad, Karnataka rural, Hyderabad, Karnataka Kannada medium, Hyderabad, Karnataka scheduled caste, Hyderabad, Karnataka scheduled tribe, and Hyderabad, Karnataka OBC, category A, B, C, D. I am not seeking for the seats which are reserved for Hyderabad, Karnataka scheduled caste, scheduled tribe, or the OBC. There is what is known as Hyderabad, Karnataka general. Now, general seat, I fulfill the qualification, being a local person, being to be treated on par, entitled to the general seat. Therefore, my lord, may I request your lordship to kindly turn to the IA which I have filed, where I have produced the seat matrix. For all the medical colleges in Karnataka, KEA has published the seat matrix. There are more than 1,800 seats reserved for the Hyderabad Karnataka category. Within that, my lord, there are open seats. My only submission to my lords is I am entitled, the once it is held that I have to be treated on par with Indian citizens, once it is admitted that I am entitled to all the general category seats, this is within that 70%. That's in that 70%. That is what will this will clarify. Not only 70%, there is a 8% in areas outside of this Hyderabad, in Bangalore. Hyderabad,
Yes.
Karnataka. In that area, no, it is in that 70% only. It is in that 70%. In Bangalore, for example, my lord, kindly, this will clarify, my lord, kindly see the.
In fact, my lords had
I
directly put it,
may complete.
he's seeking a quota in a quota.
General seat. The seat matrix will clarify this entire thing. May I request my lords to kindly see the IA which I have filed, where I have produced the seat matrix that gives the breakup of the seats of distribution of seats of the Hyderabad Karnataka category, along with my IA. Annexure 4 to that, my lord, distribution of first MBBS government seats among various special categories, both in government and private medical colleges for the academic year. This is last year's, because this year's they have not yet announced, 23-24. HK category wise seat matrix in Bangalore. This does not come under the Hyderabad Karnataka or the Kalyan Karnataka area, but there are totally 16 seats, out of which general merit is 7 seats. Then there is a general merit rural. I don't come under rural because I have studied in Ballari, which is not a rural area. Then there is a general merit Kannada medium. IA, my lord, my IA, may I request my lords to kindly, I have filed an IA on the 4th of July, where I have produced this seat matrix. Please, my lords. Annexure X to that IA, my lords. Petitioner, in the general category seats under Hyderabad Karnataka category, during the online counseling to be conducted by KEA for admission to medical course for the academic year 24. My lords?
Yes.
Yes. Yes, yes, yes. No, that is what they are contending. Yes. They are saying it is meant for citizens. I am saying yes.
Yes, that's outside 70%. But this beyond, no, not beyond 70%, within the 70% only. Within the 70% only, Hyderabad. Because those students who have studied there, my lord, born there and studied there, and they belong to that area, they will take a precedence over those.
No, I'll clarify that, my lord. This region of
That region
Karnataka
is
was
called-
part of the erstwhile princely
Earlier it
state
was
of Hyderabad.
Hyderabad.
During the reorganization of states, this
Now it is-
area was merged with Karnataka.
Now it is renamed.
Therefore,
as-
it is called as Hyderabad, Karnataka.
Yes.
It is within Karnataka.
Now it is.
But the area is called as Hyderabad, now renamed as Kalyan Karnataka.
Now they have renamed it as Kalyan Karnataka.
371J is what it provides for. Hyderabad, region known as Hyderabad, Karnataka. Because of the overall backwardness of that region, the entire populace of that, both in employment as well as in educational institutions, has been given a particular quota. Oblige.
Basically, government
Please,
has to.
please move.
Yes, sir.
Yes, yes, there is urgency. Oblige, my lords. Tomorrow. Please. Please. In fact, if I may just submit, my lord, this 371J is what is peculiar to Karnataka alone. Probably this is coming up for the first time. It is my lords, we may have to lay down the law in that aspect. That's all I can say. There may not be any judgments,
There
but there are
judgments
certain
on-
other precedents, my lord.
There are
When
judgments
it
on-
comes to all India, where there is a special category of PWD, persons with disability. There again, PWD general seats are there, PWD scheduled caste, scheduled tribe, OBC seats are there. All India counseling, my lord, OCI is being considered for the PWD general.
Yes.
Similarly, my lord, in IITs, there is a girls supernumerary special category. There, it is specifically provided in the information broadly of JEE Advanced. Yes, before.
It's reported.
Citation, my lord, I'll give the citation tomorrow. I'll give it to the court.
He's
also.
also,
I'll
he's
give
also
the
annexed a copy as an annexure. He's marked it as.
Yes, sir.
citation, I'll pass it on to the court officer. I'll do
Yes,
it
it is
in
there.
SCC online version, it has been reported. I'll give the citation to the court. But the next matter, my lord, is the
There is no problem. Next matter should go along with 43. 42. 42.
42 alone,
43, I think.
3, 43.
Tomorrow.
The next matter, my lord, is a OCI. He is not seeking for,
Reservation.
he is not seeking for the Hyderabad, Karnataka seats general, and they are ready to give it, as I have read that.
Then we are giving, that's covered by Supreme Court judgment, my lord. That's what I can say. We are giving them. He has taken also as a
There is an interim
examination.
order. They will be considering us is what they are saying. Interim order passed by my lords while issuing notice. Very well.
Yeah, this could be called along with serial number 43, my lord, in the first list. Tomorrow, my lord. Same issue. Yes, tomorrow.
Serial number
So
43.
They could be disposed of by tomorrow. Wherever there is reservation, my lord, we will have to argue. Otherwise, my lord, there is nothing in this.
Tomorrow at 2:30.
Tomorrow.
Like,
Oblige.
List number 1, serial number 2, Manjunath Ji Khandekar.
For the complainant in this matter, my lord, notice has to be issued to the accused. There was interim order on 9/3/2023. There was an interim order of stay on dated 9/3/2023, page number 9, my lord. Despite there was interim order, he has remand. Please.
Seal number 3, Srilata Nayak, party in person.
I'm compliant in this case, Your Honor. Yes.
4 adjourned. Seal number 5,
And for the complainant, Doctor. This is also the contempt petition filed by the petition. There is a final order decided by this final court not to relieve the petitioners from the post annexure A, my lord, page number 23.
seal number 6 adjourned. Seal number 7, Vinod Kumar M.
My lord, for the petition on. My lord, unauthorized statue has been put up in the public place, my lord, contrary to the judgment of the Honorable Apex Court, my lord, in Union of India versus State of Gujarat. Lordship may kindly see the photo is produced in page number 28, my lord. It's in the middle of the statue. Yes, my lord. Lordship may kindly see the statue structure, my lord. My lord, the interim order, my lord, not to further put erect, my lord, they are continuously putting. It's a former MLA, private person's statute. Yes, my lord, in the public, lordship may kindly see the Honorable Apex Court's judgment in State of Union of India versus State of Gujarat. And also interim order also, my lord, which may submit, my lord. Yes, my lord, yes. And interim order also.
What do you want to copy?
ಹೌದು ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಆಲ್ಸೋ ಮೈ ಲಾರ್ಡ್ ಅದೇ ಇದೆ in this case. Side of the footpath, my lord.
My lord, is this in the footpath?
Yes, footpath also there.
Lord, could I seek instructions and get back to my lord? Because he says it's in the footpath. It's already installed.
It has encroached the, and it has come up to the road, my lord. It creates a severe traffic block.
Lord, it might, my lord, the government in paragraph 8 may be seen, my lord. It will cause severe disturbance. It's not his case that it is causing disturbance. It will cause severe disturbance.
shall forbidden to deputy commissioner or shall size of the structure and size of the structure, size in the other details of the structure. Statute. Further pointing out whether statute is in the middle of the road and obstructs vehicular. Pedestrian vehicle traffic. No further instruction. Takes place.
Much obliged.
Lord, the statues have already been installed, my lord. Vinod, copy for him.
Seal number 8-9 adjourned. Seal number 10.
My lord, the
KV
date,
Narasimha.
my lord. My lord, the late my lord, MLA, late Alanguri Srinivas Gowda.
We are not concerned with whose statute, but we are concerned with where it is directed.
Right.
That much will vary.
Where?
In the middle of the road and obstructing the traffic, then we'll see. Supreme Court says that no such statute should be permitted on the middle. That is the only
My lord, could I have a hand delivery, my lord, so that,
concern with the location, not the person.
my lord, could I have a hand delivery so that I can get instructions immediately? Obligement. My lord? No, I can get it, I can get the information. My lord, the date, my lord.
28 August.
Yes, please.
Obligement.
Seal number 8-9 adjourned. 10. KV
Serial number
Narasimha.
10, my lord, I appear for the appellant. My lord, in both the matters, my lord, the termination of the additional government pleader, my lord, is in question. My lord, on 16/9/2022, my lord, the appellant herein had been appointed as an additional government pleader. And the term, my lord, was stated to be 3 years or until further orders, my lord, as per Annexure A, page number 24. My lord, what has happened is the doctrine of pleasure, my lord, that have been invoked by the state to say that they can oust me at any point of time. This, my lord, was subject matter of consideration. No, that portion, my lord, I am not aggrieved. There are two legs, my lord, to the impugned order. Under Annexure B, my lord, I was removed. And my lord, respondent number 4, my lord, was sought to be appointed.
I challenged both the portions. My lord, as far as the removal of fourth respondent is concerned, my lord, the learned single judge has allowed my writ petition. I'm satisfied to the said extent. But thereafter, my lord, he proceeds to state further that I cannot seek continuation of my term in view of invocation of the doctrine of pleasure. And until and unless the due process is followed by the state, I would continue to officiate as the additional government pleader. My term is for the term of 3 years. Now I am aggrieved, my lord, with that portion of the order, because, my lord, it is covered by the judgment which I had produced at Annexure C, page number 56, where this honorable court had taken a view that doctrine of pleasure cannot be arbitrarily invoked. There should be some reason, whether it is communicated or not. An unceremonious removal of an government pleader is not tenable, my lord, is the ratio that was laid down by this honorable court. My lord, that would be the binding precedent in my respectful submission. And hence, since the respondent number 4's appointment is set aside, consequentially, my lord, for my term, until and unless there seems to be any cause for my removal, there could not be a termination of my appointment, my lord, is my respectful submission. The learned single judge's order, my lord, runs into 2 legs. Please see page number 14 and 15. The operative portion of the order, my lord. The writ petition is allowed in part. The writ petition is dismissed insofar as impugned notification dated 1/1/2024 as per Annexure B, Part 1, Serial number 19, removing the petitioner from the post of additional government pleader. This is the only portion, my lord, that I am aggrieved with. The other portion, my lord, is in my favor, where, my lord, the appointment of the 4th respondent is also set at naught. And, my lord, the fresh and the 4th direction is the petitioner shall continue to discharge his service as additional government pleader till fresh appointment is made in accordance with law. Now, additional government pleader. No, that part is upheld. Now, that is the challenge that I am laying, my lord. There is absolutely no reason. Annexure B, my lord, is issued, removing me from the service. Absolutely no reason, my lord, is forthcoming in Annexure B to remove me. No, 4 is not appointed. My lord, he did not even take charge. The learned single judge set aside, my lord, the appointment of 4th respondent. And he has not challenged the order also. Now, I am continuing, my lord, as the additional government pleader. He did not take charge at all. I immediately approached the learned single judge and there was an interim protection given to me. The grievance is this, my lord, Annexure B would not give any reason, my lord, for removal of me from the service. Annexure B, page number 40, my lord, is the impugned notification at Annexure B. En masse, my lord, concerning 21 persons, my lord, in a common notification, an order had been passed to remove them. Page number 40. That is the part 1. The undermentioned district government advocates or additional government advocates have been relieved from the duties of the post mentioned before their names in terms of Rule 5(6) of the Karnataka Law Officers Rules 1977 and have been granted 1 month's retainer fee in lieu of 1 month's notice. This is all that, my lord, it read. My lord, 2 of them, my lord, approached the learned single judge, and, my lord, concerning them, the orders have been passed. The rest, my lord, have not challenged. This, my lord, is squarely covered, my lord, by the judgment rendered by this honorable court at Annexure C, page 56, where, my lord, the doctrine of pleasure, my lord, had also been looked into. And this honorable court was pleased to hold that it cannot be in an arbitrary manner without any reason. And a specific, my lord, observation is an unceremonious removal of the pleader on the political dictates is contrary to law.
My lord, for that, the concerned rule has not been challenged. No, 5(2). My lord, a division bench, my lord, a coordinate bench of this honorable court
My lord, Annexure C, my lord, page number 56. Please, my lord, I'll just.
My lord, 27th February, that's the one?
I pass. Lord, page number 51, my lord.
My lord,
Page number
paragraph
51
4.
of the compilation. Hanumantrao Kulkarni versus State of Karnataka.
Yeah.
This is what was, please.
My lord, paragraph 4 of that order, my lord, judgment.
Yes, my lord, Hanumantrao Kulkarni versus State of Karnataka. It's a division bench ruling.
Coordinate.
Commencing from page number 51, my lord. Yes, ma'am. The relevant portion, my lord, would be at paragraph number 6. My lord, this ruling, my lord, was rendered in the year 2006. My lord, Annexure A, my lord. Page number 24, pardon. Lord, subsequent to passing of that order, my lord, the Honorable Apex Court, in my lord BP Singhal's case, my lord, have read down as to how the doctrine of pleasure will have to be looked into. And it is following that judgment of the Honorable Apex Court, my lord, the learned single judge in another matter, my lord, while interpreting the doctrine of pleasure concept, my lord ruled in the light of the very same rules that there cannot be an unceremonious removal without any cause. And hence, my lord, with the subsequent rendering of the judgment by the Honorable Apex Court, the division bench ruling, my lord, was not applicable. My lord, I was appointed on 16/9/2022. Madam. Very.
Obliged. Film 11, Mukkanappa SB.
Here for appellant, short accommodation, my lord. Appellant, in the short accommodation, senior is 11.
Film 12, Arjun. 13, Shivraju MK.
Not single judge passed an order. Counsel for the accused Maladi. They have filed a complaints of, the Leonard single judge passed an order responding to effect kata as per the gain of the Akkupatra in favor of the petitioner within 2 months. They have filed a affidavit stating that, complaints affidavit stating that the file is not available in my office. I have written a letter to the Taluk office of the Tahsildar. Shows that in the.
My senior is in not well, my lord. Kindly grant 1 week time, my lord. My lord?
That file is not available.
My lord, there is the original file is with the Tahsildar in the Tahsildar in Bangalore North Taluk, my lord. Akkupatra issued by the Tahsildar of North Taluk, my lord. Akkupatra issued by the Tahsildar of Bangalore North Taluk, my lord. Original file is not with the accused, my lord. Therefore, the genuineness of the document Akkupatra is.
So I seek for a passover in this matter. I seek for a passover in this matter. It may be taken up at 2:30. We have filed our affidavit.
Connected matter on 2/9 is posted along with connected matter also 2/9.
Film number 14, Badri Vishal.
The complaint. Order the single judge, my lords, at page number 13. proceedings for occupancy rights had to be undertaken by the state. Page number 13 is the 14, my lords. End of page 14. Within 6 months, my lords, the proceedings had to be completed.
Lords, we had filed the affidavit, my lords, that the land tribunal was yet to be constituted and it was in the process. Now, my lords, the land tribunal has been constituted on 29/7/2024. Lords, immediately once the first day of sitting, their matter will be posted. It's in Kannada, my lords, my apologies. It is just constituted on 29/7.
A time limit.
Please.
Please. Please. With Bharat? Varun Joshi, my lords, appearing. Varun Joshi.
Seal number 15.
Here for
Naveen
the
Chandra.
petitioner, my lords. My lords, here the order that has not been complied with is at page 42. If my lords could see the operative portion of the order, which is at page 56, para 10, my lords. My lords, all the petitioners. Page 56, last page of the order, para 10. The impugned annexures were quashed and the government was respondent authorities were directed to reconsider the case of the petitioners for appointment to the post of elementary course teachers, it is, having requisite qualification in terms of RCI Act and to complete it within 3 months. My lords, all the petitioners were persons who were appointed on contract basis as special teachers for teaching children with disabilities. They were appointed on contract every year, and for nearly 15 years, they had the Rehabilitation Council of India Act prescribed qualifications. Thereafter, the impugned the orders, the government changed the qualifications. Then the learned single judge said, those are quashed, you reconsider their applications. Thereafter, my lords, we have not been reconsidered within 3 months. In fact, we sent them a notice, and my lords, they give a reply at 153. After this order had come, the respondent authorities, in fact, even gave a response saying we have directed the authorities to consider. My lords, even now the new school year has started. The children with disabilities need to be taught and they need the special teachers.
We filed the compliance affidavit, my lords. It's been considered. The endorsement has been issued at annexure R2,
Yeah.
page 14 of the affidavit.
No, we have not been served.
No, your colleague took, we haven't served it.
No, absolutely.
Annexure R2 is the reconsideration, my lords. That's,
No, I've just got it now, but they may have, I don't know whether they have considered these persons, the petitioners have to be considered within 3 months. I'll go through it. Maybe taken up next week, my lords, I'll just go through it. 12th is fine.
that's we have filed it. It was being filed on 4th July 2024.
My lords, I'll need to see I will need to see what compliance they have filed. Let it be on 12th, I will. Wait.
Hearing on interlocutory applications, seal number 16, Pradeep HS.
For the
I'm
accused, your
for
lordship.
petitioner.
Your lordship, we filed for correction.
I have
IA number
filed
1
the
of 24,
application
your
for
lordship.
recall the order on the ground that they have make a false submission that saying that the association has been registered. Therefore, this honorable court has disposed of my contempt petition. But now he has come up with another application by saying that it is already got registered. As per my knowledge, your lordship, the association has not registered from the competent authority.
Your lordship, we have produced annexure R1 at page number 7 with our IA 1 of 24, your lordship. That itself proves that the registration of Apartment Owners Association has been completed. And we have produced a copy of that registered deed of declaration with the competent authority, your lordship, and got an acknowledgement. That is in accordance with KOA 1970. The learned single judge had ordered us to register our association from welfare association to association under Karnataka Apartment Ownership Act. And the act provides that a deed of declaration has to be registered with the jurisdictional sub-registrar, and a copy thereof after registration has to be produced to the registrar of cooperative society, your lordship, and that has been complied with. If your lordship may look at page number 7 of our IA, it talks about it. It is the registered deed of declaration, your lordship, which was registered on 9/3/2023, your lordship. Last year, within 2 months after the order of the honorable single judge, we have registered our deed of declaration, and a copy thereof was produced, and an acknowledgement was received from registrar of cooperative society, which is at annexure R2, your lordship, page number 85. That itself proves that we have complied with the order and there is no contempt from the end of the accused, your lordship. However, inadvertently, there has been a mistake in the order that within 10 days, the registration would be completed. However, the registration has already been completed. So that is the correction that we are seeking humbly, your lordship.
Your lordship, they have. It is not done. It is a deed of declaration, your lord. They have not produced any registered certificate, which is necessary under the Karnataka Ownership Flat Act.
And the deed of declaration, it is a forged document without producing the GPA. They themselves, they have registered. No one has given any GPA to that effect. I have obtained the RTA wherein the register of sub-register stated that there is no GPA. On the ground of GPA, they have obtained the deed of declaration before the sub-register.
No, Your Lordship.
The
No.
registration, earlier registration was cancelled in view of the single.
Your Lordship, previously the accused, the association was registered under Registration Act of 1960 and we were that registration was cancelled and we were directed to register ourselves under Karnataka Apartment Ownership Act of 1972. And we have done accordingly by following the prescribed. It is cancelled. It is cancelled. Yes, Your Lordship, and liberty was reserved with us. Yes, Your Lordship. We were given liberty to the registration was quashed and we were given liberty to register ourselves under the appropriate act that we have taken steps for register. We have complied, Your Lordship. Direction was to. Your Lordship, the Honorable Court had quashed the registration and given us liberty.
Yes, sure.
Yes, Your Lordship, we are in compliance. We are for the accused. Association accused. Your Lordship may look at.
1 and 2 is the state government, that is the cooperative register in earlier.
They have not been made party, Your Lordship. They have not been made. In the contempt petition, they have not been made as a party.
In contempt petition, they are not party. There is a specific direction against these respondents to register.
Your Lordship, if Your Lordship may look at. Your Lordship.
I will file necessary application to implead them.
Your Lordship, one humble submission.
In earlier, we have made, the office has raised objection that to delete their name, therefore.
Number 70, Rohan Kotari.
Here for the petitioner, my lords. This is the lake encroachment related matter. In fact, on the last date, if my lords recollect, the learned AG had in fact filed a policy for MOUs to be
They
executed.
given the objection yesterday. We'll file a reply, what can be complied, what cannot be complied, if you can amend it. Lordship may have it up next week, my lords, based on their objection.
I filed my objection.
Yesterday, my lords.
I
So
also
therefore,
filed my objection.
we look into it. Of new lake policy, my lords, so for which they are given certain suggestions. Give kindly grant us.
12th, is it okay?
in-
If 12th is okay, my lords have given another date on 12th as well, if it's convenient, that is convenient. 9th, wait.
In the meanwhile, they have to file the status report.
We'll do it.
As
that
ordered
is-
earlier.
That-
What was ongoing, it's not, that's what. No, it's not there. They're not filing it.
Huh?
They have to do ongoing, whatever.
19th.
Please.
Settlement 18, Manisha Konguri.
For the petitioners, ma'am.
For respondent number 4. My lord, we are filing compliance affidavit as per instruction of this court on 27/5/2023 on 2 IAs that have been filed by the petitioners. We have served a copy.
Just received this. So I may be granted a week or 2 weeks time, my lord. Because we'll have to analyze the data.
Very well. Yes. For respondent. Obligement.
Settlement 19, Suresh HS.
I am for petitioner, my lord.
Yes, my lord, I am appearing for the petitioner, my lord, in this case. And my learned colleague is physically present in the court too, my lord. My lordship, this is a restoration application, my lordship, filed on the behalf of petitioner, my lordship, for restoring the read petition number 13024/24, case title as Priyadarshini S versus State of Karnataka and others, my lords, which was dismissed as defect could not be cured within the time, my lordship. My lordship, in this present case, my lordship, petitioner had engaged me as a counsel, and my lordship, I am Delhi-based advocate. I have engaged local Bangalore-based counsel, my lordship, for the filing purpose and other miscellaneous appearance, my lordship. My lordship, this writ petition was filed through the local counsel, and this honorable court was pleased to issue notice to all the respondents on 9th May, my lordship. And my lordship, this matter was again listed for the hearing on 3rd June, my lordship. But on that day, matter was not taken up, my lordship. And I was granted 3 weeks time to cure all the defects, failing which matter would be deemed to be dismissed automatically without the reference of the court, my lordship. And my lordship, I had relied and trust upon the local counsel to cure all the defects within the time, my lordship. Even they assured me defect will be cured within the prescribed timelines of this honorable court order dated 9th of May 2024, my lordship. But in the meantime, my lordship, due to personal difficulty or health issue of the local based council of Bangalore, my lordship, and time taken to search and engage new counsel, my lordship, defects could not be cured, my lordship. And thereafter, my lordship, I have engaged another local advocate, my lordship. This restoration application was filed through whom, my lordship, and mentioned, then it get listed for today hearing, my lordship. So, my lordship, I humbly pray from this honorable court, kindly one opportunity may be granted to me, cure all the defects in the interest of justice, my lordship. Defects will be cured within the period of 1 week, 2 weeks, my lordship.
You own time, Mr. Counsel?
Yes, my lord.
Yes. For restoration, my lordship. It's for,
Is dismissed.
My lordship, it is a matter of
IN
public
number
import.
1 of 24, this application is filed seeking restoration of the petition which was dismissed on the ground of non-removal of office objections within the time stipulated. Post of learned advocate for the applicant assures that whatever objections are left out from being removed shall be removed within the time which the court may grant now. Full stop. Any of the said assurance, and in order to enable the petitioner to contest his case on merits rather than being thrown out on technical consideration, the prayer for restoration is granted. The writ petition number 13024 of 24 paragraph will be restored to its original file with all orders subsisting therein, on condition that the office objections shall be removed within 2 weeks from today, failing which the petition shall stand automatically dismissed without reference to or order of the court.
So much grateful, my lordship. So much grateful, my lordship.
bless me.
So what's the date?
Non-filing of reply in contempt matters, seal number 20, Swami
We are
NK.
for the accused in this matter, my lord. May I request for a week's time, my lord, I will come. I'll file my reply, my lord. Sorry, my lord. It's being for 4 years to issue an appointment order.
Last time also you prayed.
Yes, my lord. I'm sorry, my lord. There's some inconvenience with the file, my lord. That is the issue of issuing an appointment order. Sorry, my lord. A week's time, my lord, I will make sure that it will be.
The order was passed on 13th July 2023 by Lawrence Single Judge, whereby respondent 2. The Commissioner Brihad Bangalore Mahanagarpalika was directed to consider the representation public notice dated 29th May 23 of the petitioner within 4 weeks. What was for what? The representation was for appointment on compensatory ground. Full stop. Learned advocate for the respondent number 2, Mr. So-and-so appears and prays for time. Full stop. The present proceedings have witnessed the request for asking for time repeatedly. Full stop. 1 year has passed since the directions are not complied with. The paragraph, the court grants 2 weeks time to respond to, within which the directions shall be complied with, failing which the court will have to be stern, requiring personal presence of the.
Much obliged. I'm sorry.
Tend over to 19th of August.
Seal number 21, Bharati GB.
This matter may be tagged along with writ appeal number 623 of 24 months.
Appeal.
Please.
With appeal number 623 of 24.
24 months.
24. Which is an appeal arising from the same order.
Number 22, Ravi Shankar Shastri.
Waiting for the complainant, my lord. My lord, we'll file it during the course of the day, my lord. We are filing it. Affidavit, we are filing the affidavit during the course of the day, we'll file it.
But decided or not decided?
My lord,
Representation is decided or not decided?
It has been considered, my lord, even we have issued a communications also. We are filing the reply, we are filing the affidavit, my lord. Today, we'll file
Today?
it before the registrar.
2:45, 2:30, or tomorrow?
Yes, my lord.
Tomorrow?
Yes, my
Tomorrow.
lord. What they say in the reply is that, my lord,
It's filed?
my lord, they have given me the copy, my lord.
Where is it?
We have the copy. My lord, the land of the petitioner was, my lord, illegal.
it.
Land of the petitioner, 5 cents of land, residential house of the petitioner, my lord, complainant was, my lord, taken away without, my lord, due process of law. And they have formed the road in the said land, my lord. My lord, after, from 2014, there are.
We don't have the reply.
I, my lord, the facts are like this, may I submit, my lord. 2014, my lord, the land of the petitioner complainant was, my lord, illegally a road was formed by the corporation, my lord. Then, my lord, we make several representations and ultimately they decided to, my lord, give a alternative land for the land, my lord, for which they have used for the road. But when they have not, my lord, even after their orders, my lord, they have not complied with the giving of the alternative land, writ petition was filed before the Honorable Court, my lord. Learned single judge, my lord, directs them to, my lord, consider within 3 months, my lord, by referring to their own orders. Now in the reply, they say, my lord, they have decided to give monetary compensation since alternative land is not available. And my lord, they say I should give certain documents at again, my lord. That is their communication, my lord, annexure. R7 is their communication which says that, my lord, it is in compliance of this order. R8, my lord, at page 20. We have issued a notice from 6/1/2024.
What compensation you are paying?
My lord, first we have given,
What is the amount you are paying?
my lord,
What is the amount you are paying?
no amount, my lord. They say I should again give the documents of title, then RTC, then encumbrance, every document I should give for getting the compensation, what they communicate to me as per annexure R7, my lord. To ascertain the value of the property. To ascertain the value of the property, they have to produce the documents of title, hence we have sought it now. But in spite of 4 notices we have issued, my lord, they have not given any reply or even they have not produced any document.
So there is no direction to give the land only.
My lord, the may take, my lord, the direction in the honorable single judge at page 9, my lord, in the contempt petition.
Page 9, yes.
Para 4, my lord.
Yes.
Therefore, it is expedient to dispose of the petition, directing the respondent to consider the representation dated 21/9/2019 submitted by the petitioner at annexure A
As approved order in accordance.
in the light of the internal communication dated 30/4/2016, annexure C. That document was placed, my lord, at annexure D in the contempt petition. The translated copy, my lord, gets it at page 16. May I read page 16, my lord, 2 paras. With reference to above subjects, my lord gets it at page 16, my lord, annexure D. With reference to above subjects, request was made to pay compensation for forming the road in survey number 52 so and so measuring 5 cents situated at Kannur village which land belonged to Srimati Lakshmi and others. The lands in survey number 287/1, site number 23 measuring 0.03 acres, site number 40 and 41 totally 0.03 acres situated at Pada village which lands remained in Ashaya scheme were identified as alternate land for survey number so and so. My lord, they identified the alternate land also. But I have no difficulty, my lord, if they pay the compensation also. But the grievance would be, my lord, after considering all my documents and title and all aspects, my lord, they pass an order to give alternative land to me, my lord.
Now they say, my lord, under Ashraya scheme, alternative land cannot be granted more than 2 cents of land. Therefore, they will pay the monetary compensation. But for which they again me ask, my lord, to go back for the year 2014 by asking, my lord, same documents by issuing this order. It is nothing but, my lord, to overreach the order of the honorable single judge, my lord, and making me to.
My lord, there is a restrictions only to grant only up to 1.5 cents it can be granted from under the Ashraya scheme. So we couldn't give them a alternative land, my lord. Hence, once we have also extended the benefit of TDR. Even that was not acceptable. Even a meeting was held on 26/12/2023, my lord, where the children of complainant was also present on the said meeting. In that meeting, my lord, they have sought for alternative land.
May make, my lord, annexure R3 and R4 are the communications made by them, my lord. They again ask the title documents, revenue documents, and encumbrance certificate, my lord, and conversions order. Annexure R3, my lord, and R4.
So they want what kind of document now?
Please, my lord.
They want some documents.
Yes, my lord.
Title
What
document.
kind of document?
My lord, they say, my lord, I should give a title document. My lord, it is of the year 1977 grant, my lord. Then, my lord, they say I should give the RTC, encumbrance certificate, Aadhaar card, conversion order, and sketches. My lord, they have verified it, and, my lord, they said they will give the alternative land. Now, yet again, my lord, in contempt proceedings, to overcome this, they ask these documents, my lord. So far as the one document, title document is concerned, my lord.
But how they will assess the compensation?
My lord, they say, my lord, they will purchase the land, my lord. Since their communication is
Amount, how they will ascertain?
they have not communicated anything, my lord.
We have this communication in respect of the
On
same, my
what
lord.
basis you will ascertain the amount of compensation?
My lord,
Some
upon the
method-
document which they have produced, the document, upon the documents
the-
of title, my
Who
lord.
is the authority?
Mangalore Corporation.
City Corporation.
Mangalore
Bangalore.
Corporation,
You comply with, otherwise we'll call him.
my lord.
You are just dodging the compliance.
No, my lord, kindly, it may be passed over. My senior will argue the matter.
Then why did you waste the God's time?
I'm sorry, my lord. I've maybe posted tomorrow.
They want sale deed.
Yes, my lord. They say, my lord, sale deed or title document.
You give it.
My lord, my difficulty was, my lord, it was 1977 grant to the complainant's husband.
No, it is sale deed in which year?
70. It is not sale deed, my lord. They say, my lord, my title document. Sale deed, partition deed for number 10 or LRT order or court order, they say. My lord, while allotting alternative land, my lord, the communication I have produced at annexure C in the contempt petition, these original grant records were not available with the office of the Tashildar. Therefore, my lord, a register containing the entry was given to them. They accepted it and they said, my lord, they will allot alternative land. Now, yet again, my lord, similar actions they want to do from the complainant side, my lord. In fact, I was informed by my clients that, my lord, they have given all the documents.
Your land was acquired.
It was not acquired, my lord. Forcibly, they formed the road. I was displaced from my residential house. Till today, my lord, no acquisition proceedings.
Then they purchased from you.
Now they say they will purchase the land from me.
Now they will say, they are saying that they will purchase from you.
Yes, ma'am.
Even in writ petition, they have sought for compensation, my lord. They have not challenged the acquisition.
It appears that compensation is determined.
It is not, my lord. They say, my lord, I should produce the document for determination of the compensation. My lord, these documents, my lord, I had produced on the earlier occasion, and order were passed, my lord, stating that alternative land will be given. When the directions was issued to give alternative land, they say, my lord, I should again produce these documents. Now in the contempt proceedings.
Land is already utilized in road.
Yes, ma'am. 2014, they have utilized this road for the road purpose, ma'am. Since, my lord, they say alternative land is not available, at least, my lord, compensation they should determine and pay, my lord, is my respectful prayer.
My lord, in
You don't have the revenue record also.
Please, my lord.
You have the revenue record of your land which was taken away by them. Something in the revenue record.
My lord, every revenue RTC entries were there, my lord. Then I have produced the register entry, my lord, showing that this land was granted to my husband.
Then it is
now
there.
let them produce.
It is
We
with-
have, my lord, we have given.
Then why do you?
Now let them produce, my lord. In reply to the my notice,
My
they
lord,
have not
may
produced the
make one
documents. And,
prayer, my lord. My lord, we will tender all documents which we are having, my lord, at again. Let them determine, my lord, let this contempt petition be kept in, my lord, for some time.
We'll keep it pending.
Yes.
Oblige. Oblige.
My lord, my instructions are there. My client has given it to them, my lord. Already they have given it to them. One RTC entry they have to give is
With
my.
regard to the compliance of the directions of learned single judge, it was stated by learned advocate Mr. So and so the respondent that the alternative land was not available, therefore it is decided to pay the compensation to the complainant. Full stop. Regarding fixation and compensation of the compensation, comma, it appears that the respondent needs some documents relating to the land of the petitioner which was utilized in road, full stop. While learned advocate for the complainant would submit that asking for these documents is intended only to harass and while away the time, comma. It was submitted that even it was submitted that in any view, the complainant would submit whatever documents
Available documents.
he is in possession about the land in question.
My instructions are that, my lord, I have called, my lord, just now to my counterpart. He said, my lord, except on RTC, every documents were already tendered.
To the respondent authority. Full stop. Within 10 days.
Please.
Within 10 days. It is expected of the authority that even if a single document submitted by the complainant to the authority relates to the land, comma, the authority shall proceed further to determine the compensation and file necessary affidavit in that regard before the next date. Full stop. That's it.
Please, ma'am.
Stand over to 30th August.
Grateful.
Determine and pay. You are agreeable to compensation.
My lord, my clients have.
Determine and pay.
Seal number 23, Reynald D'Souza.
Appearing on behalf of 17 families who are the home buyers, my lords. The learned single judge at page number 284 had directed the state government to implement these RERA execution orders within a period of 3 months.
My lords, this process of implementation is being done, my lords. I pray for 3 weeks' time, my lords, to file the status report. We have identified the properties, my lords, to be attached. I'll place it before your lordship, my lords. 3 weeks' time may be granted.
Lord, I beg to represent, my lord, the respondent number 5, accused number 5.
Where are the directions?
The direction is to the government, my lord, in respect of, my lord.
Which page? Page
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 285.
84
285 minutes,
280?
please.
The last, the next year, my lord, 285.
Yes.
Recovery proceedings, my lords.
There is one.
Pursuant to the directions issued by the RERA.
You will need 3 months time.
3 weeks, my lords. I'll place the status report, my
3 weeks.
lords.
Stand over to 2nd September.
Please.
At the request of learned additional government advocate, Ms. Pramodini Kishan.
Even
It is
may I just
expected
seek
that
for one indulgence, my lord. On behalf of, my lord, the accused number 5, that we have to place a statement, my lord, there is, Lord, my humble submission is, my lord, in fact, such revenue recovery proceedings notices were issued. And my lord, what the government authorities did was, they went on issuing notices in respect of private properties without even ascertaining, my lord, to whom the property belongs, etc. Then, my lord, in a writ petition, my lord, another coordinate bench of this honorable court directed them to file impleadment applications before the original authorities, that is the RERA authorities. And RERA authorities, my lord, before issuing instructions for revenue recovery, should hear us and then determine who exactly is the entity or person against whom the revenue recovery proceedings have to be marshaled. My lord, this process is underway. They have been, my lord, they are repeatedly filing, my lord, impleadment applications, and the RERA authorities, my lord, we are told that RERA authorities are passing impleadment orders, and my lord, we are yet to be heard. And my lord, till that happens, my lord, once again, going back to the original course of revenue recovery proceedings, my lord, which was faultily done, which we had questioned, my lord, once again, that will, my lord, intercept. That's the reason, my lord, I will place that. I think my learned friend was appearing in that proceeding also. I'll place that particular order. And in the meanwhile, what the RERA authority has done based upon, my lord, the directions issued by the coordinate bench of this honorable court, where, my lord, we were asked to implead, and my lord, we were given liberty to go before the RERA authority to say whether it is my property or the property of the company, can it be proceeded against, my lord? These are the things which are still kept open. In the meanwhile, my lord, if the government goes ahead, my lord, the same kind of, my lord, catastrophe will be repeated. My lord, place those details. My lords may kindly grant us a week's time. We'll place those details with a brief, my lord, statement of my lord facts.
My lords, my humble submission is that
19.
So,
I have a submission to make.
Let us see what is the council is producing.
My lords, what has happened is they have submitted that the company has no properties. That's the reason the
On
honorable
19th,
court,
we'll consider. Let the things come.
we will place those things.
the government has identified the properties which the company has, my lords. That's the reason.
19th.
So great, please.
Seal number 24.
My lord, I appear for the accused person.
My lord, this is the, I'm the, I'm
My
the.
lord, my
complaining party.
respectful submission is kindly see, my lord, the order passed on page 15. KPSC is not made a party to the contempt proceedings. So we are not the appointing authorities. Lordships will recollect.
My lord, the
Lordships
direction is
will-
accused for the
Page
accused number
15.
3, my lord. Kindly see
Just complete my
page number
submission.
34. Yes. Page number 34. Kindly see the 34. Yes.
So who is appointing authority?
KPSC, my lord, Karnataka Public Service Commission, which is, my lord, second respondent in the order, is the appointing.
Not party.
Lordships may, sorry.
My lord, the kindly see the order, my
It's
lord.
not made him,
Direction is particular to the third respondent. Third respondent has
Lordships
to
may
appoint
see-
the petitioner.
Yes,
My lord,
there is an
this
order, but we are
yes.
not the appointing authority.
Appointment order.
This whole
You are
selection-
the appointing authority. My lord, petitioner, respondent, accused is the appointing authority.
Allow me to complete, my lord, my submissions. Otherwise, my lord, his problem will not be solved. I am arguing on his behalf. This issue. My lord, my respectful submission is, my lord, KPSC is the appointing authority. He produced a fake certificate, PH certificate. And based on that PH certificate, my lord, he applied. Now, my lord, he claims that he is under general merit quota. The honorable court has directed us to consider in the general merit quota. That we are not disputing. We are filing an appeal independent of this, my lord. But the fact is, my lord, all selections. This is, my lord, a residential education society. My lord, entrusts all its appointments through KPSC only. We are a state government body, and all appointments are made through KPSC only. So if he doesn't make him a party, my lord, his grievance will not be returned. We cannot appoint we have no powers to appoint. KPSC, let him make KPSC a party, my lord, if they are ready, independent of that.
May I submission? Lord? Kindly see the order, my lord. Kindly pass the page number 34. Direction is the third respondent is the appointing authority, and second respondent, my lord, the KPSC is the only selection authority, not the appointing authority. Appointing authority is the third respondent accused, my lord. And the court has directed third respondent.
What is the objection in adding a party?
Lordship. My lord, direction is the only third respondent. So therefore, if I made a party to the second respondent, obviously will raise the objection. There is no direction to the second respondent, who is the selection authority. Direction only to the third respondent. So therefore, I may not.
What is your objection if court permits to add the party?
My lord, goes prolonging. My lord, we already made the.
Then the council said there is not the appointing authority.
No, he is the, they can file, they cannot file the affidavit, my lord. He has to file affidavit. My lord, he is not ready to file affidavit. My lord, the appointing authority is the third respondent. Lordship.
Contempt letters.
Lord, third respondent is the appointing authority. Lordship.
Lord, I think he is arguing against himself, saying, my lord, that I am not the.
Who is for third respondent?
Third is accused, my lord. Third respondent is the.
Standing counsel, my lord, before this honorable court. He can serve it on the standing counsel appearing for KPS. There are several standing counsels not for KPS.
You are for whom?
I am, my lord, for the third respondent. Accused.
Yes.
In the, sorry, my lord, I am for the sole accused. I'm sorry, sole accused, and my lord, the third respondent in the writ petition. He has only made me an accused.
Third respondent is third respondent.
So who is for third respondent?
Third respondent KPSC. My lord, this is Karnataka Residential School. Lordship.
Who appears?
My lord, on behalf of third respondent, my lord,
Yes.
the Bob. My
Lord, I am for.
Learned counsel.
My lord,
Since the direction contained in the order of learned single judge brought under contempt is against respondent 3, which is Karnataka Residential Education Institution Society, and none appears on.
I am for the third respondent.
Then to you
The
can't.
accused, sole accused. I'm submitting, Lord. He's not.
Lordship.
He is not letting me speak.
We'll take up on 13th.
Grateful.
Lordship.
Next.
My lord.
13th will. There is
He
cacophony.
is confusing, lords, still because he is the appointing authority, his third respondent still he is not ready to submit before the court. Lordship. Kindly.
Your Honor.
Your Honor,
Appointing authority, Miller, I'm seeking appointment.
Your Honor.
Merit is candidate.
After recess, then
Yeah,
continue
you-
the,
Miller,
we will continue the cacophony,
Your Honor,
2:30, 2:30,
2:30.
Your Honor. Cause list number 76, still at 23, it might not arrive this afternoon. It may be posted for orders tomorrow, for interim relief orders. Since there is no argument in the, because the court has recognized the cause of action.
Without hearing, it can't be posted for order.
Number 25, there's a next matter. Now, there is a direction, it was filed with a single prayer, but the court felt the need to expand after looking at the pleadings, the scope was expanded and the area was also expanded. And there is a direction to list it before the conference on minute to consider the matter. There is an order passed in that regard. This is abuse of the girls, children, girls, that they are abused.
Time.
No, it has to be listed in the conference of your lordship. There is a direction already in this regard. Yes. Some sensitive things, I cannot express in the open court. That's the reason. Paragraph 7. What had happened in this case was that the writ petition was filed with a single prayer, that the children who market the toys and other things, the traffic junctions, they are deprived of the education. But looking at the pleadings, the court felt that larger interest is involved in this, and therefore they expanded the scope to the entire state instead of just confining to Bangalore city. And also, they called for a report. Shocking thing is certain things are mentioned in the report of the Secretary of the Legal Services Authority as to how these girls are treated in the night, the small girls. So therefore, the court felt let it be discussed in the conference hall and
We'll fix a date then.
other than 12th minute, 12th has been.
Any date.
20th.
Please, any day other than 12th. Okay.
Lordship. Kindly see the order page number 34. Actually. He is the third accused number. Accused number 3 is the respondent in the writ petition. He is the accused. Himself is saying that he is not appointing. Court is directed to appoint the third respondent. Court is directed to third respondent to appoint the petitioner. Petitioner is a meritorious candidate, Lord. He is general meritorious candidate, and he is also a handicap.
The counsel for third respondent says that it is not the appointing authority.
Lord, he is appointed. Kindly see order 30, page number 34. Actually. Page number 34. Actually.
Then
My Lord, kindly.
So what do you propose?
Page number 34. Actually. May I read it?
Why don't you join the appointing authority?
Yes, sir.
Why don't you join the appointing authority?
My Lord, I am the meritorious candidate, and they are not. I am selected by the KPSC and given refer to the accused number 3. My Lord, they are not appointing me.
Direction in the direction in the order of learned single judge is against this number 3 to appoint the petitioner by considering the petitioner as a candidate under the general merit category and to pass the necessary orders within stipulated time. When the breach was paragraph complained of, when the breach of the above direction is complained of by filing this contempt petition, learned advocate so and so, who appeared for respondent 3, stated that respondent 3 is not a appointing authority. Therefore, in order to ensure in order to solicit compliance of the direction, the complainant need to join the appointing authority. Full stop. Learned advocate for the complainant shall consider the said aspect. Stand over to 13/8/24. You decide whether
Sorry.
you want to. Yes.
Moreover, direct to file the affidavit, Your Worship. He has not filed affidavit, my lord. If it is not appointing authority, direct to file the affidavit in respect of.
Saying to the court.
My lord, orally, my lord is saying, he is appointing authority. He is direct to file because court has directed it.
Law.
Direct to file the affidavit, Your Worship.
So you're not willing to join?
Grateful.
Well, yesterday. Let it go to third September. Which is a matter. Withdraw. Okay. In absence of it. Figures on the record. Memo for withdrawal dated 22/6/24. It is stated that the respondent have considered the claim of the complainant, therefore the complainant is not willing any further to proceed with the matter. Permission to withdraw the petition is granted, dismissal is withdrawn. By filing memo of withdrawal dated 3/7/24, it is stated that the accused has delivered and handed over the subject matter vehicle to the complainant, therefore the contempt proceeding does not survive. In view of the memo, in view of what is stated in the memo, the contempt is disposed of as not surviving.
Twenty-seven, my lord, I'm sorry.
Memorandum memo dated, undated memo along with the affidavit, which is on the record of the contempt petition, indicate that the directions brought under the contempt jurisdiction are complied with. In that view, the present contempt petition is disposed of as not surviving.
Okay. We filed a memo for withdrawal, may kindly permit.
Learned advocate so and so appears to point out to the court that the memo of withdrawal is filed. In view of the memo, the permission is granted to withdraw the contempt petition.
Grateful, madam.
It is accordingly disposed of. Withdraw.
Lord, we have filed out. Twenty-seven, I'm sorry, I'm not able to hear the serial.
Synopsis is there. Stuff authorities are killing.
Filed our synopsis, my lords, on behalf of the appellants.
I'm copying, I don't see now.
We have given one the list of authorities. That's our synopsis we have filed, if your lordship please. Quite a brief synopsis, my lords, filed out. Of the written, part of written submissions on behalf of the appellants.
Now, according to them,
My lords. It's a pleasure which they can revoke at any point of time.
no, according to them, if we have correctly understood,
Please.
the very prayer in the main petition, whose petition it was?
My lords.
Your petition.
Yes, petitions.
Become infructuous. That is the crux of their case.
That now, my lords, that was.
You have to go to the prayer and he have to answer how it is surviving.
My lords, yes. There are two things here. I understand that. Now, my lords, the issue before this court was, my lords, with regard to an impugned order which withdrew the pleasure or which cancelled my nominations, withdrawn my nomination.
That is page 118.
Lords, the first one was, yes, my lords, I would say it starts from 99. Then, my lords, later it was revised where the word specific sentence that until further orders were deleted. Oh, my lords, that was the issue. Now, before this court, now they want to contend that my period is over, for which, my lords, there were no pleadings. Then I'll place a memo also with documents to show, my lords, number one, it's an admitted case. Their case is, my lords, today from what their arguments or the written synopsis, that there has been a reconstitution. The university has, my lords, filed a written submission where they say on 16/6/2021, 9th syndicate was reconstituted for a period of 3 years from 16/6/21 to 15/6/21. Now, in any of the documents which they have filed along with their memo, there is no such document of reconstitution of the syndicate, except the syndicate was being reconstituted every time, my lords, under an order. If your lordship takes their memo of documents which was filed, my lords, it is dated 19/6/24. Filed on behalf of respondent number 2. 19th of June 2024, my lords.
Yes.
Lords, in that, if your lordship kindly see, the last notification of reconstitution, would your lordships get it at page, document number 7 at page 24 in that memo, my lords. After that, there has been no document to show reconstitution at all.
Page 24.
24, my lords, along with their list of documents, memo with the production of documents your lordships would get.
That is 17/6/15.
Yes, 17/6/2015.
After this, there is no
Reconstitution orders at all, except that they are periodically, my lords, nominating members of syndicate under various categories. The last of the nomination, I will just submit a memo with documents now. Lords, I will just show how they have been nominating every time members of the syndicate, academic council. Though, my lords, we did not want to. If your lordship sees, if their contention is accepted that there was a reconstitution and the term of body of the 9th syndicate has expired in June 2024. In this memo, if your lordship sees, I have produced the various nominations which the state has been doing from time to time. In that, please come to the last of the nomination done on 16/11/2023 at page 19 in that memo, my lords. Of course, there are various categories of nomination, but under 24, running page 19. Even in this, they nominate for a period of 2 years. From 19/11/23 to 18/11/25, one person. The other person for a period of 1 year. Then one more person, my lords, for a period of 1 year from 19/11/23 to 18/11/24. Now, if this contention that syndicate has been reconstituted in 21 is to be accepted, then, my lords, every nomination will have to get wiped out from June 24.
No, the present, according to them, the 3 years are getting over when?
June 24 is their stand.
Already over.
That is their stand now in the writ appeal.
Correct. So that term started when?
My lords, according to them,
It ended in, according to them, in June,
According to them in June, my lords.
June 24.
It started on 15.
Started in 21.
Yes, they say
21 to 24.
16/6/2021 up to 15/6/2024.
Now this page 19 you are showing,
Yes, my lords.
the revised notification. These are the petitioners?
No, these are different nominations. What I'm trying to point out is, at every point of time, if your lordship sees so many nominations we have included, at every time they are nominating persons. There has never been the. In. In fact, my lords.
Even their period comes to an end, my lords, after this period. It is during this block of period it comes, my lords. Irrespective of, even though the period is for 3 years, my lords, it need not be that they're appointed on day 1. They may be appointed after 6 months, 1 year, 2 years, 2.5 years. But the period will get over when the block period that during that during this block period of 3 years, my lords, under section 31.
In fact, the last syndicate meeting which was called was on 3/7/2024 of fixing the date of syndicate meeting on 11/7, which your lordship should get at page 43 in that memo which I have filed now. But then they send us a mail saying that the scheduled meeting is cancelled.
Why you are passing such an order, page 19? In the middle of the term. In the middle of the term of the syndicate. Which is.
Correct.
we
In
knew
fact, they should be
that-
very clear in that.
No, you know that it is going to expire in June 24. It is provided that the appointment will be for 2 years up to 18/11/25. Why should you pass such an?
That is the understanding of the registrar. Nomination is made by the state. But may I just point out, my lords, memo for production of documents which my learned friend has filed starts with, my lords, the first of the notification on 31/5/1997. After, my lords, the university was established.
Your memo is dated.
Just now, my learned friend showed, my lord.
19/6/2024, memo for production of documents is by the university.
That's their memo, my lords, which was filed, which I pointed out just now.
Yeah, just. Is 19?
No, this is a notification, this filed on 19/6/2024.
Now, where is your memo?
It's kindly see the very first document.
Give
one more.
Lords, my learned friend is referring to the university's memo dated 19/6. But in the same memo which I pointed out, page 24, it's the same memo, my learned friend.
Let me just point out what I want to put.
Since I have not completed, though you.
Yes, what you are showing?
It is memo for production of documents filed by the university. Document number 1 is a notification dated 31/5/1997. But after the university was constituted, these syndicate was constituted, my lords, for the first time on by this notification, which was from 31/5/1997 to 30/5/2000. successively every 3 years, my lords, it is reconstituted, which is found, my lords, item 2, 3, 4, 5, 6. Up to 9, lords, every 3 years, lords, it is reconstituted. Maybe in some cases there is a notification, in some cases there is no notification saying it is reconstituted. But the fact remains when we read section 31, kindly see section 31. Save as otherwise provided in this act, the Senate, Syndicate, Academic Council shall be reconstituted at or about the time every 3 years. And members of the authorities, except ex officio, thereof are up to the date of next reconstitution. So irrespective of the date of their inducting into this body by notification, which is by nomination, the period of the constitution or reconstitution is required to be every 3 years. Now, my lords, these notifications which I mentioned in these documents show every 3 years cycle.
But only thing which struggles in our mind is that despite expiry of 3 years, why we are not formally reconstituted?
Your Lordship may kindly just answer that. It's a serial number 28, my lords, in the list of documents. Serial number, just Your Lordship may take the index which the university has produced. The serial number 8, my lords, just the index itself, serial number 8, page 2, page 2. 8th syndicate was constituted by Rajiv Gandhi on 16/8 for a period of 3 years, completing on 15/6/20. This was challenged, my lords. The division bench of this honorable court at page 55 says that it expired on page 55, serial page, internal page 25. The Lordship may kindly see, even otherwise, the respondent in the absence of an interim order in the appeal has subsequently completed the tenure in Senate and Syndicate of the university, and the tenure of the respondent, even others, would have expired on 15th October 2021. Actually, it should have been, my lords, 15 June 2021. So 3 years, it is expired on 15/21. What we are saying is from 21 to 24 is the next 3 period. Identical case, my lords. Here also, during the litigation, they finished a period of 3 years.
Showing 55, page 55.
Page 50, I'm sorry, my lord, I just went a little far.
55.
55. Wait, we'll leave it. I'll come to that. Yeah, page 55. Even otherwise, the respondent in the absence of any interim order in this appeal has subsequently completed the tenure in Senate and Syndicate of the university, very same university, and the tenure of the respondent even otherwise would have expired on 15/10/2021. It should have been June 2020. June 2020. Very same university, 8th syndicate was the subject matter of this division bench judgment. Therefore, my lords, 3 years should have been taken from that period. Now, my learned friend is saying, my lords, he wants more than the period. That is why I said the writ petition has become infructuous in that. So read that. Page 49 may be kindly seen, my lords. Para 10. I'm grateful to my friend, my lords. Page 49, para 10. Section 31 of the Act provides the Senate and the Syndicate and the Academic Council shall be reconstituted at or about the same time every 3 years. And the member of the authority shall, except in case of ex officio members, should hold an office as member thereof up to the date of the next constitution. Thus, a plain reading of section 31, it is evident that the same provides the Senate and Syndicate and the Academic Council shall be reconstituted at about the same time every 3 years. Section 31 further provides that authority except ex officio member shall hold office up to the date of next reconstitution. In other words, the member authority have a right to continue in office only up to the date of next reconstitution, and the reconstitution of Senate, Syndicate and Academic Council has to take place in 3 years. Thus, section 31 does not.
Where you are reading?
Page 49, my lord, of the same judgment.
Same judge.
Same judgment, para 39.
Paragraph 10.
Para 10. It's in furtherance to this, my lord, page 50. I just read it, my lord. This is what page 49. I'll read it once again, my lord. Section page 49, para 10. Section 31 of the Act provides the Senate and Syndicate and the Executive Council shall be reconstituted at or about the same time every 3 years, and the members of the authority shall, except in case of ex officio member, hold office as members thereof up to the date of next reconstitution. Thus, on a plain reading of section 31, it is evident that the same provides that the Senate, Syndicate, and the Executive Council shall be reconstituted at about the same time every 3 years. Section 31 further provides that authority except ex officio member shall not hold office up to the date of next reconstitution. In other words, the members of the authorities have a right to continue in office only up to the date of next reconstitution, and the reconstitution, Senate, Syndicate, and Executive Council shall take place in 3 years. Thus, section 31 does not prescribe for a tenure of 3 years in respect of nominated member of Senate, Syndicate, and Academic Council. However, the aforesaid power cannot be exercised in an arbitrary manner subject to judicial review. After stating that, my lord, page 55, and this is the very same university, same people, my lord, next batch. After this was the 8th, now we are in the 9th. So therefore, my lord, that is why the petition has become infructuous. He is getting more benefit than what was in his initial prayer in the writ petition itself. That's all.
Lords, my learned friend referred to page 55 to say there is a typing mistake. It should be 15/6/21 and not 15/10/21. Please come to in the same judgment, para 5 at running page 38. Running page 38, my lords. Para 5 is the learned advocate general's arguments. Lords, that's the argument, Prabhu, the learned advocate generals. Please come to running page 39. Lords, from the top, about 5 lines. It is also argued, your lordship gets it, my lords. It's also argued reconstitution of the syndicate and senate has to be made category-wise. It is pointed out that the term of nomination is going to expire in October 2021. So the Advocate General there says October 21, court records October 21. Today, the Advocate General says it is a typographical error, it should be June 21. So they are themselves not sure when the reconstitution has to take place. In fact, the registrar is not sure. There is his letter, if your lordship sees, he also writes in the very same memo at page 131. If it is October 21, my lords, we have time till this year, October. Typographical error.
What is the interim order operating? They will continue.
We will continue. Because they are nominating, lords, if your lordship sees my memo for everything, they are nominating as and when they want.
All.
Just one other submission. In fact, my lords, what my learned friends have on this side have argued, my lords, very same judgments were considered by the division bench in the earlier round of litigation and the single judge, my lords.
Correct. Absolutely. But there is
therefore, except the members being nominated members being different, my lords, legal principle in earlier division bench and the single judge is the same.
Lords, I would beg to differ there. In the earlier round, the words, my lords, that's why I would say the difference is, my lords, in the earlier round, what was there was until further orders of the government. But here the government consciously removed it. There should be a reason, my lords. By an order, my lords, earlier, the first nomination was on 13/11/2022, which was identical, 13/12, which was identical to the earlier nominations, which said 3 years with immediate effect or till further government orders. But there was a reason why the government consciously, my lords, deleted those words on 6/2/2023. Consciously, they have removed the words or until further orders, whichever is earlier. Now, my lords, and then this university also issued a notification saying for a period of 3 years on 7/2/2023, with effect from 30/12/22. Now that period, my lords, one judgment of this honorable court in respect of veterinary university, this court has said if the term is there, even if it's a nomination, that has to be respected. Otherwise, my lords, I would fall into the same division bench judgment. The difference is, once the government withdraws its right of pleasure, or otherwise, my lord, there should be some meaning why they withdrew it. That's the distinction here, my lords. In this case, my lord, the learned single judge accepts term is 3 years. The learned single judge also holds that the settled position of law is even if it's a nomination, there can't be an arbitrary withdrawal of nomination. But there is no answer. After that, my lord, there is no answer. We had pointed out, my lords, about the casual vacancies and the term, that there should have been a finding. The learned single judge holds that even if the pleasure theory is withdrawn, even then it remains a nomination and they can withdraw the nomination at their will. That's the difference between the earlier round of litigations and this litigation. In my list of authorities, my lords, I've given one judgment. In ILR 2017 Karnataka 4239, which has dealt with almost the same thing.
Yes.
My lords,
Yes.
in my list of authorities which I have given, my lords, please come to the one judgment, my lords, I had submitted on the last date, my lords, on behalf of the appellants. My lords, in that page number 57, my lords, running page 57, ILR 2017 Karnataka 2439.
Yes.
My lords, this related to, of course, the veterinary university, my lords, relating to nomination itself. In that, my lords, if your lordship sees, all the judgments are referred to regarding withdrawal of nomination. And my lords, please see the provisions are also culled out, which are paramateria, which your lordship should get from, my lords, page 73, para 11 onwards. Or please come to straight away para 70, running page 75.
Para 11.
My lords, para 11 starts where their lordships have culled out, my lords, at running page 73. There it is called as a board of management instead of, my lords, it starts at running page 73, my lords, top view. Para 11 it commences in the bottom of that page. Constitution of Board of Management, your lordship should get. It calls, please come, my lords. The nominations are mentioned, but if your lordship comes to running page 75, The last one, proviso, your lordship should get at running page 75. Then, my lords, withdrawal of nominations or thing, the lordship should get subsection 7 at page 76. Which also said that any person nominated could be removed. These provisions were considered. And then please come to para 12. At running page 78. It starts with from the amendment as made. It is seen that category of nominees in 1 to 4 of other members remains to be the same, but only the nominating authority is substituted with government instead of chancellor as it existed earlier, which is clear from the words, for which emphasis is supplied. Subsection 3, which existed in the original section 27 and continues to exist after the amendment also, which provides that the term of office of the members of the board, other than ex officio members, shall be 3 years. This would mean that the other members who are nominated by the chancellor were assured the term of 3 years and the curtailment at pleasure is not indicated. As such, the right has vested with such of those members who are nominated to hold the office as nominated members for a period of 3 years from the date of nomination, unless the contingencies for removal as provided under subsection 7 to section 27 are arisen and the procedure contemplated was followed. Almost identical provisions even under the Rajiv Gandhi University. Now here, my lord, there are two things which happens. Under section 24 of the Rajiv Gandhi Universities Act, a nominated member or an elected member, there is no differentiation. Everyone is called as a member. They are there for 3 years. And in our case, the section also says, my lord, 31 says about 3 years. In our case, the order is specific that it is for a period of 3 years. If such being the case, then there should have been an answer, my lords. It can't be, my lords, if the government says until further orders, but then by a conscious decision removes that, that means my term is assured. And if your lordship sees along with my memo, which I have filed, all the nominations are for a term, which has been going on from time and again. Lords, if your lordship sees the latest memo, which we have filed, my lords, periodically for every body they are nominating. And to say that it was done, it could have been done, no, that is not the case. And this issue never arose in the earlier division bench judgment about the term of office. It's a in fact, 20th of January 2024, they have nominated a person which we have pointed out to the syndicate for a period of 1 year. At page 31 in my memo, your lordship should get that. That's the issue. I've given the judgment with propositions, my lords, because that judgment has referred to all the judgments which they are referring to.
Justice Bopanna's
judgment has referred to every judgment. And the single judge relies on singles case, even they rely, even we rely, my lords, only to the effect that it can't be an arbitrary withdrawal of nomination. That's the only.
I'll just supplement what I appear in the connecting.
Oh, no. My learned friend, having appeared in the earlier occasion, having succeeded, my lord, cannot take this contention, my lord.
What the learned AG.
Oh, he was the old one.
But what the learned AG is referring is Lord, that earlier division bench judgment, lords.
He has succeeded for the state. He has succeeded. What I am trying to argue now, madam. Now we can't argue.
No, it has been.
He has stopped, my lord.
He has become wiser.
It is.
Wiser now, to come this
No,
side.
it is very famously said, lawyer, there's no estoppel as against lawyers are concerned.
On the light.
But anyway, no,
No estoppel for lawyer.
no estoppel. But at any rate, I thought I must but place my submissions on a slightly different note, Lord. Nothing to do on this question. But what was called into question before the learned single judge is the order of removal, Lords, which was preceded by a government order dated 24/5/2023, which my lords get it at page 140. That omnibus order passed by the government.
The chief minister, the order. What was that, 24/5?
But may I request lordships to kindly see that omnibus order passed by the state government, not by which every other member were removed. And lately, government order. But that lordships will get it at page 128. Page 128. But this was
128 of?
128 of writ appeal 870 of 2024. Second appeal, not in which I represent. Yes, yes. 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 Where is that Tiffany? Yes. Now in that page 128, my lords, lords, permit me, I'll just read it out. It's a very short order. As regards to public universities under the Department of Higher Education, the government of Karnataka, in exercise of the powers conferred under Karnataka State Universities Act 2000 and other separate acts.
Impugned.
Yes, this is the impugned order. But kindly see, my lords, how the government directs them at the last few sentences. All non-executive members, lordships get that. All non-executive members made to the chairs of studies established in public university nominations and nomination of all non-official members made to the Board of Governors in respect of private universities under the Higher Education Department have been ordered to be cancelled with immediate effect. It is, my lords, in this background, the removal is at page 120. Therefore, my lords, the challenge to our removal my lords, was not on just on account of the fact that there is a tenure of 3 years being given, but on account of the fact that this order by which we were removed was an act of arbitrariness, violating Article 14 of the Constitution of India. And persons who are nominated to universities, higher academic councils, must not be removed by the authorities under the university at the diktat of political masters. That's how, my lords, the writ petition was crafted. But it is this challenge, my lords, which the learned single judge did not favor to. But it is nobody's case that the university thought it fit, the government thought it fit rather, to recall them on any other reasons. They squarely say, en masse, it's just not to this university. Every university nominee was removed on account of change of government. But I had an occasion to address your lordships along with Lordship Justice Dixit in that other university, VTU University, where these arguments were advanced at length, stating merely because there is a change of government. En masse removal is impermissible. Is fundamental ground on which this writ petition was filed. In fact, the division bench judgment which the learned advocate general relies upon. May I request lordships to kindly see page 175 of that judgment. The division bench qualifies the power to remove. May I request lordship to kindly see page 175, para 10. Qualifies this power to say that this cannot be done in an arbitrary manner. Page 175, last words commencing from the last few sentences. In other words, lordship.
Paragraph 10.
Para 10 words, the sentence commencing from the word in other words, the members of the authorities have a right to continue in office only up to the date of next reconstitution. And the reconstitution, Senate, Syndicate, and Academic Council has to take place in 3 years. Thus, Section 31 does not prescribe for a tenure of 3 years in respect of nominated members of the Senate, Syndicate, and the Academic Council. However, this is a declaration. The aforesaid power cannot be exercised in an arbitrary manner, and the same is subject to judicial review. Therefore, my lords, if the government, my lords, after having exercised a power purely based on a diktat for extraneous consideration, not relevant for the purpose of exercise of its powers, cannot not take umbrage and say that your 3 years has come. This is one aspect of the matter. The division bench, my lords, in that judgment records, a learned friend has already read out, in the last, that same judgment at page 181, that the term comes to an end on 15/10/2020. As regards interpretation of Section 31 is concerned, but in all fairness, I must submit, and I had argued there, and the court also has recorded, that whenever we are appointed, even in the middle, we hold only the residuary period, and it comes to an end at the time of reconstitution. But after having said that, I must also bring to lordship's notice, the plea of reconstitution has been placed only for the first time before your lordships. The question before the single judge was as to whether our removal was arbitrary based on extraneous consideration or not. That has been turned down, and we are in appeal before your lordships. That question necessarily has to be answered. Either not the state before your lordships now says, we recall those orders, treat them to continue as members up to the next reconstitution. We shall reconstitute, taking into consideration their services. I certainly, my lords, cannot have any objection. But they can't say, my lord, that the order of removal stands, but we will go on reconstitution. But we are more concerned about our, but if lordships permit me to use the word unceremoniously, the way we have been sent back, then, my lords, more than concerning our tenure. And at any rate, my lords, now, if they want to reconstitute and, my lords, replace the Senate, Syndicate, or the Academic Council, they can do so with effect from 16/10/2021. Therefore, my lords, even according to them, we would be then entitled to tenure up to 16th of October 2020. My lords, in the order of the single judge. Lords, in the order of the learned single judge, at page 34, translation version. May I draw lordships' attention to just one point, Lord, where the learned single judge in fact records that these removal are based on the note sent across by the Honorable Chief Minister at page 34. At page 34, internal page 34, lordships. There are certain Kannada words thereafter, lords. Lordships, it says the notification contained 2 conditions. The nomination was not for a fixed period. It was a nomination as a member and chairman until further orders. I'm sorry. Page 34, internal page 19.
Internal page?
Internal page 19, 19.
Notification contained two conditions.
Yeah, two conditions. Nomination was not for a fixed period. It was a nomination as member and chairman until further orders. Here again, after the change in government, a tippani, that is note, from the chief minister emerges. The tippani reads as follows. It is in Kannada, not there is an English version. Only that portion which the learned single judge extracts. That Kannada portion which is extracted. Chief Justice Arvind. This is the note given by the Honorable Chief Minister. It is hereby directed to pass orders cancelling the nominations made by previous government, various corporations, committees, autonomous bodies, and other government and semi-government, and other president, directors, members with effect from 22. So the state is bound to explain before your lordships as to how they could have acted on omnibus orders unless there was personal satisfaction about the unsuitability of each of the persons to the post concerned. And I'm grateful.
That's all. Still you want to argue?
No,
You can argue, no, welcome.
no, leave it at that.
Anything? Yes.
No, only thing, my lords, division bench covers the very same issue, my lords. Single judge also considers with regard to the same university, very same contention, very same judgments has been considered, my lords. So therefore, my lord, two aspects, right to nomination, my lords, on merits, division bench covers it, my lords, as well as a single judge. And the whole issue becomes academic in view of the period having expired, my lord. That's the whole point, my lord. So therefore, my lords, the period having expired, all this may not be gone into, my lords. So therefore, my lords,
No, academically, there is a line of judicial thinking coming out from the judgments that even if the doctrine of pleasure applies, the action can't be arbitrary.
no exercise.
What do you have to say about it?
Well, in fact, there's a idea of judgment in of this court itself, my lord, where the court says, my lords, in fact, can I permit you to read the provision section 31, my lord, for a moment?
But that is not true. Doctrine of pleasure doesn't contemplate any further thing.
Correct.
You are at the will of the.
That's the point, my lord. That is the fact that the pleasure.
Single has considered, Lords, in single's judgment, Supreme Court says, and
That-
there was a federal view and the English view, that there is absolutely no right. But in India, they say,
Yeah, yes, you are right.
there's a slight change, you can't have that's the only issue.
That's fine distinct.
That's the only.
No, in fact, that
May not be that relevant here, but.
not BP singles judgment, all the judgment, my learned friend had argued, my lords. In the earlier, in Rajiv Gandhi University, court said that principle does not apply when it is a nomination of a statute. In fact, that-
the state, my lords, relies
can I-
upon section 21 of the general clause.
Can I request, my lord, in the compilation of judgment, page 39, my lord, for a moment, my lord, compilation of judgment, page 30, I mean memo for production of citation.
By?
By the respondent university, my lord. Page 39,
39.
running page 39.
That BP single.
And BP single is referred to in the very same division bench of the very same university, BP single, Southern thing, then next page 40, Om Narayan, all these judgments, all this, and in fact, the single judges, Justice Bopana's judgment, which my learned friend refers to, all these judgments which they produced along with the compilation of documents, all are considered by the earlier division bench with regard to same university. The only difference is that was 8th syndicate, now we are in the 9th, my lords. And what is even more identical in both the cases, that 3 years, all of them are able to complete that 3 years, and they wanted to argue beyond the period of 3 years, my lords. That is also identical, my lords. Therefore,
That is all today is what? So it will be for orders on Monday,
Yes.
without being reserved.
without being- grateful to me. I just wanted to draw your lordship's attention that Shankaragowda's judgment yeah, of His Lordship Justice Bopana, which my learned friend tried to show, has been considered by the learned single judge at page 52 onwards. It points out that the other division benches have taken a different view and therefore is accepting that. Yes, it's not as though it has gone unnoticed, it was noticed. And from page 52 onwards, there is a detailed discussion on that aspect.
Of the learned single judge.
Let's appear for the appellant in connected matters, my lords. I adopt the arguments of the learned senior counsels.
Single judge's judgment contains two parts. One, we are dealing with Rajiv Gandhi. There's another batch which does not deal with Rajiv Gandhi. That's all I want.
How many appeals are there? Two.
There are three petitions here, three appeals relating to Rajiv Gandhi. Learned judge.
No, this, today we are dealt with how many?
Three appeals.
All three appeals.
Three appeals.
All three appeals, but different.
Pertaining to Rajiv Gandhi University.
All.
Arising out of single judge common order, but different appeals have been filed. That's all.
Order is common.
Common judgment, common
Judgment, but the other issue, other writ petition was pertaining to some other issue, we are not concerned.
Let's appear for appellant in connected matter, my lords.
It's just one last submission, lords. Last submission. Lords, this October, which my learned friend tried to point out from the judgment. Kindly see, my lords, this memo. The 7th syndicate was reconstituted. At page 24, my lords, in the index, your lords will find document number 7, notification dated 17/6/2015. Now, my lords, under this, the constitution was from 16/6/2015 to 15/6/2018. Thereafter, my lords, 3 years block period has been counted, and that's the reason why, my lords, it is June and not October.
One request. This change of government should not result in automatic decision. There are two decisions, but I'll just place it on the Lord's part.
In fact, that later I'll just endure also, my lord. Very same contention was
Petitioners have very conveniently not brought out to the notice of this honorable court that this removal of those words were on the eve of the election, anticipating, my lords, that the government will not continue. Just few days before the election was announced, this removal of until further order was made by the previous government. So nothing works out, my lords, on the basis of the government's change in the government.
So, fifth.
Please.
please.
Anything?
Senior is.
You're uneasy?
Please, Lord.
You're uneasy?
No.
Yes.
I was making submissions with reference to the. If you're not in discussion.
We are just asking that.
No, I too was asking if he has got any difficulties on his behalf also I can place it. What?
Don't make him uneasy.
No, thank
In absence of his senior.
you.
And also don't us make uneasy.
Never, it won't be. Well, try to restrict it within 10 minutes or so. I'll try myself to restrict it, not that the court.
No, you can. This is all in lighter way, don't take.
I was referring to that order passed by the learned single judge, page number 5051. I'm not reading it as anyhow. So far as, if my lord could kindly peruse, so far as page number 51 is concerned, it consists of regarding, I'm only by parawise I'm going it as such. That is with reference to the two dates, which the same date has been referred.
How it is same?
Pardon?
How it is same?
I did not follow.
How the two dates are same? Preliminary notification, final.
Preliminary notification.
Why it is same?
It is not so. There is no final notification at all.
There is no final notification.
There is no final notification at all. It has mistook in the sense that another order was passed, what you can say, invoking the powers under section 17(1) of the Land Acquisition Act and 17(4) of the Land Acquisition Act. One is the section 4 application is there, that what you can call it as a preliminary notification. The other one is only a government order, but the learned judge mistook it, or I could say misreading, nothing beyond those two words. Coming to the paragraph number 3. This paragraph 3 consists of the two portions. Number 1, with the reference to the Karnataka Village Office Abolition Act, which I have already read in the earlier part of my submissions, which is part of my notes also. This particular writ petitions in paragraph number 3, 5271/95, etc., which has been referred on the 5th line below from the bottom. My lords, therein we have pointed out, number 1, land is different, owners are different, and it was in no way connected. Apart from that, after 25 years, the writ petition was filed, it was remanded. After remand, I have pointed out, along with the necessary page number, also to the effect that the respondent's name has been shown. I mean, once the matter goes back, it's normally the original applicant, he stands as a petitioner. But the application was filed by the company requesting the Tahsildar to do it. When the matter is seized by the competent authority under the Village Office Abolition Act, is the Assistant Commissioner. That too delegated power. Deputy Commissioner is the competent officer, Assistant Commissioner is the delegated power. But they felt it convenient to move. I will use only that. They felt it convenient to move with the Tahsildar. They moved it, Tahsildar passes an order. Even though it is not connected, but they are relying upon it. Therefore, I have brought to my lord's notice that it is he is not a competent officer, therefore the KO Act does not apply as such. Then, my lords, in the paragraph number 3 only, on the next page number 53, learned single judge refers to respond number 7. If my lord can kindly see the 4th line from the bottom. By Srimati Rajamma and others who are respondent number 7. I have brought 7 to 12. The other day I have brought to the court's notice that there are two Rajammas are there. They are different. Page number 555 Kannada version. Page number 575 is the English version. And petitioner is Rajamma, wife of Chikkanna Reddy, response number 7 is Rajamma, wife of Krishna Reddy. But the learned single judge proceeds on the basis that it is the same Rajamma, which is inaccurate according to my submissions is concerned. And it could be seen, it could be verified on page number 596 and 610 also. I need not, because yesterday I have shown it, my lords, I need not once again. Now, so up to now I can, coming to the paragraph number 4 is concerned, the submission is made by me. I need not repeat it. That is pertaining to the order passed by my lord Justice Santhan Gowda as he then was as a single judge in writ petition number 30999 of 2009. It was read and discussed before my lord itself. That was on account of delay in respect of 2 acres. On account of delay in respect of the 2 acres, and they have sought for a lapse of the notification. Learned single judge at the preliminary stage has dismissed it on account of a delay. But it is my submission to my lord is that observations are not. When all these facts were not brought before the court has passed such an order that is neither a precedent nor binding so far as the petitioners are concerned. Here, my lords, page number 54, para number 5. That being the position, just I shall read 1 or 2 sentences. Invoking the section 24, 25, 127 of the Karnataka Land Revenue Act 64, to set aside the mutation entries. I am underlining the word to set aside the mutation entries. Rajamma has approached it. It is inaccurate observations. My lord may kindly turn to the page number 630. Actually, I have not read it yesterday. Volume 4. Volume 3. Page number 630. It was only 2 names are available in the cause right, in the record of rights. Therefore, an application was filed to delete the name of the company. It was, kindly see, it was not by virtue of any mutation entries are concerned. In fact, my lords, another on the same paragraph, the 3rd line from the bottom, it is recorded by the, I shall read it and point out how factually inaccurate. It is recorded by the Tehsildar that although notice is issued to the respondent has not appeared and the respondent was not able to substantiate by producing the documentary evidence to show how it acquired the right. The learned judge proceeds that the respondent was not appeared, which respondent means the company, which is factually incorrect. Page number 630, I pray my lords to kindly peruse page number 630, unnumbered paragraph 2. It's the English translation. The counsel for the respondent, Sri so and so, is present. Respondent is present and argued on behalf of MSPP by producing mutation assessment receipt ILRR numbers dated so and so, along with the written submissions stating that the said land is acquired for the industrial purpose and the land tribunal has rejected the farm number 7. Therefore, my respectful submissions to my lord is certain factual aspects were totally into the learned judge proceeds on the wrong footings, which is against this paragraph number 5, page number 630. Then, my lords, paragraph number 6. In paragraph number 6, learned judge, I shall read that 4 lines, which is once again inaccurate. Nevertheless, it starts in paragraph number 6, 4th line. Nevertheless, immediately after the orders were passed by the Tehsildar on 24/1/2007, the petitioner got executed the sale deeds 3407, 10/107, 23/307, 11/107 in her favor. In fact, some of the sale deeds were executed even before the orders were passed by the tribunal. Sorry, Tehsildar. It is on page number 55. My lord may kindly turn to my notes. I have prepared a chart which is available on page number 10 of my synopsis. Page number 10 of the synopsis. For every survey number, I had given the RRT dates. Page number 10, every survey number, RRT dates have been given. And the sale deeds, the respective sale deeds were also pointed out. By these columns, I have prepared a column, my lords, on page number 10.
Page number 7.
Ink page 10 and 11, my lords.
10 and
10, ink page 10 and 11.
yes.
True, man. True. My lord may kindly peruse that last RRT number and the date on which the Tehsildar has passed the order. 25/1/07 is the date of the order of the Tehsildar. Then 3407, I have purchased the sale deed. Likewise, 23/8/06 is the order passed. 11/1/07 is the sale deed. For the purpose of, I make the details are available on the page number 1 and 2 and need not be, but it is accurate, my lord. R26, page number 682, R30, page number 680. Like that, the next two also. 24/1/07 is the order passed by the Tehsildar. 23/3/07 is the sale deed. Now coming to the point is concerned, what I wanted to convey is, here also, learned single judge has seen only one date and proceeded, which is inaccurate. Now, my lords, on page number 56. Page number 56, third line, 4th line, the deputy commissioner, probably with this, the judgment will be submissions on the judgment. The deputy commissioner, after 4th line on page number 56, deputy commissioner, after securing the records, found that name of the 4th respondent was entered in the land records, index of land, etc., in terms of MR number 4/76-77. This is the basis. It was found that the lands in question have been converted from agriculture to the industrial purpose. This is inaccurate. Kindly see page number 633 and 637 in English and Kannada. And I have produced that MR also by way of order 41 rule 27. The purpose for which is the Tahsildar who has examined it, he says that this MR is not connected with this land. Page number 633. I don't know, my lords. My lord, may kindly turn to page number 637, English version is there. The 637 paragraph. The previous records regarding this land have been examined. It means RR number 702 and MR 4/7677 are not connected to this land. Since such an observation has been made by the learned single judge, my lords, I have filed an application order 41 rule 27 before this honorable court, before the division bench, to substantiate my contention that this MR4 is pertaining to one site measuring 28 feet into 40 feet, a site measurement transaction. It has been produced, volume number 4, page number 856. English version. ಯಾವ್ದದು? 854. Oh. Application. No, my lords, it is not in the volume number 4. It is by way of applications it has been produced. Page number is the same. Order 41 rule 27 application, I have filed it. Page number 856 is the English version. That Xerox version is also produced, Kannada language is also produced, and English. It is measuring 856. It is not connected. Therefore, if my lord could kindly peruse that, well, I'm not reading. It is totally not, it is measuring 40 feet into 28 feet. So, my respectful submissions to the honorable court would be the factual aspects on which the writ petition, the order is being based on wrong assumptions. Therefore, the conclusion arrived at by the honorable learned single judge, my lords, requires a reconsideration by this honorable court. That is my submission. And with reference to this, I'll pose one question, my lords, very interestingly. Page number 58. Fourth line, last word. This court is also of the opinion that, having regard to the admitted fact that the lands in question are not agricultural in nature, since an industry was established consequent to the acquisitions made at the hands of the state, so and so. I am posing, my lords, one question which was I am unable to understand or reconcile. If the land has been, let's assume, if the land has been acquired, it has been converted, it has been used for industrial purpose, what for the record of rights are maintained? Whether the record of rights could be maintained in respect of the non-agricultural land? My respectful submission is no. The record of rights are applicable only in respect of the agricultural land wherein tax is being assessed and paid. 25 paisa, 1 rupee, 10 paisa, whatever it may be. Once it has converted into non-agricultural, more so, it is of 70 years or the 80 years old. How can it remain as in a record of rights? The very fact that the company is agitating the matter under the record of rights, that itself demonstrates it is an agricultural land, number one. Number two, if it is an agricultural land, under the Karnataka Land Reforms Act under section 79A and B, company cannot hold the agricultural land. It cannot hold it from 1/3/1971. Therefore, my respectful submissions to my lord, so far as the suspect is concerned, it requires a consideration. I will take another 3 minutes only by. Oh, good. Cyber good. I'm not reading the judgments, only point out. And they'll let it go. ಇಲ್ಲೇ ಇದೆ, ಇಲ್ಲೇ ಇದೆ. My lords, I have produced the judgment and also the proposition of law. And the paragraphs also I have pointed out. I am not reading the paragraphs also, my lords, only 1 or 2 sentences in each paragraph for my proposition, nothing beyond that. The first propositions which I am using is section 24 and 25 of the Karnataka Land Revenue Act. Tahsildar was empowered to conduct an inquiry under the inherent powers regarding the entry. That, my lord, would get on ink page number 4, paragraph number 5, but I'm reading it only 3 sentences. Last, from the bottom, 1, 2, 3, 4th line. From the bottom, 4th line. Under section 24 of the Act, Tahsildar, being the revenue official, can exercise its powers to determine any dispute between the state government and any person or between the parties to any proceedings, and the said proceedings has to be concluded as a revenue code. Similarly, section 25 of the Act empowers the inherent power to the Tahsildar to inquire into the interest of justice or to prevent the abuse of process of the revenue code. So therefore, my lords, without there being any mutation, some entry was there. To remove it under section 24 and 25, applications have been filed. That is the first proposition. In the same page, about 14th line, it may be difficult, my lords, just I shall read it, and I already made a submission. This court, while dealing with the matter covered under the KVO Act, has held that the Tahsildar had no jurisdiction to evict the appellant therein under section 7 of the so and so. Under the KVO Act, the Tahsildar has no power. That is the one proposition. This second proposition, I am relying upon this judgment. Division. Then, my lords, coming to the next proposition is any entries, revenue entries, shall be preceded by an mutation register, and inquiry should be there. I'm depending upon 2012-13 SEC 759. Relevant paragraphs would be 21 to 23. The relevant line, I mean, to put it in one sentence, on ink page number 16, 23. Paragraph number 20. The benefit of this provision can be availed only if it is shown that the entry has been made in the record of rights in accordance with the relevant statutory provisions. In other words, if the entry has not been made following the prescribed procedure, the presumption contained in section 133 cannot be invoked. So 21 to 23 are the relevant only for that purpose, my lords. The entry of the company, why I am making this is, entry of the company was not preceded by any inquiry or the mutation. Then comes the 22, Lively SC, page number 806, non-disclosure of the relevant materials amounts to fraud and deceit, paragraph number 19 and 23. For this reason, my lords, I need not read all those things, my lords. Just I'll put it in my words like this, 19 to 23. My lords, here are the petitioners who are the agriculturist landowners, this and that. The other side are the company. The company, definitely they are well read, they have got all the documents. They have got these documents, they should have placed all the material before the court. Whatever the best, only they cannot pick up few material from their file. And company is there, they have maintained the records, government records, this records, everything they have suppressed to that effect. Therefore, this provision failed. Then comes, my lords, regarding the few judgments which it has been used against me. I am depending upon the next judgment, 2005, 1 SEC 608. Relevant paragraph is 18 and 19, which is available on ink page 30 and 30. Fifth line from the bottom on ink page 30. Paragraph 18 is completely irrelevant, but I shall restrict. State versus Ratanlal Arora, it was held that here the same cannot have any, in a case, decision has been rendered without reference to the statutory bars. The same cannot have any precedent value and shall have to be treated as having been rendered per incurium. The present case stands on par, if not better footing, the provisions of section 439 so on. Then, my lords, on paragraph number 9, quoting certain English judgments, etc., the last two lines in that, State of UP versus Synthetics and Chemicals Limited, page number 31, paragraph 19, last two lines. To perpetuate an error is no heroism. To rectify it is the compulsion of the judicial conscience. With this, my lords, with this, I'm done with the matters. I'm grateful to the Honorable Court for having given me an opportunity, whatever the possible way we have placed it. And obliged to my lords. I'm concluding.
Tomorrow, my lord. Senior case.
Where is your? When a parted matter, you should continue, otherwise you close the matter, all right, tomorrow. But make a point that when the matter is parted, you should not discontinue.
Please.
Henceforth, we will not tolerate. Tomorrow. Tomorrow is what date? Tomorrow is Thursday. Tomorrow, tomorrow.
Your Honor. Your Honor, for cause list number 76.
What do you want?
Might be heard now or tomorrow morning first thing, I'll be here.
What is it?
I would take not more than 10 minutes.
What are the office objections?
The office objections are, I have already addressed those. I went to the office, they said the file has to be there for me to comply. It is minor edits.
Comply within 3 days.
I just have to give a written submission, Your Honor. I have to give a written submission, and then I have not filed a memo for filing additional documents. I have filed a memo enclosing the writ petition 13823 of 2023 and the
What are-
objections filed.
What are official?
A copy of that. I'll give a written submission to the office to comply with the office objections. But I may be heard tomorrow morning.
Office objections along with the party submissions for a compliance of the instead of memo. What are you saying?
I would take under 10 minutes to introduce the writ appeal to seek interim relief orders.
So office objections dispensed with on Tuesday it will be listed. Tuesday.
I mean, there is urgency in the way of, for the interim relief. Also, if the respondent is given few weeks or months, the earlier is better. I'll take Tuesday, Your Honor, but kindly accommodate in the morning session itself so that I introduce it right in the morning.
Tuesday.
I appear for the respondent, my lords.
Yes.
I am yet to receive instructions, my lords, because this matter I have been nominated. Because before the learned single judge, some other counsel was appearing. I would request some 2 weeks time, my lords.
No, the party in person is interrupting every time.
Tuesday. Thanks.
So 6th will take up.
Please, my lords.
Tuesday.
PAL alleging violation of the UGC guidelines in promoting a person to the post of professor, assistant professor initially and professor by the second respondent university.
But this.
I have read a small list of dates, short list of dates.
Now we are seeking writ of co-warrant.
Please, minutes.
Writ of co-warrant.
Co-warrant.
So then how come this it will come here? It will come here in this court.
PAL methods.
PAL.
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 Co-warrant.
PAL.
Please, minutes.
Yes.
My lords, petitioners are public spirited citizens. The appointment of fifth respondent is under challenge before this honorable court. He was initially promoted as associate professor of the second respondent Bangalore University. and thereafterwards on 12/2/2020 as professor of the second respondent university. My lords, in the matter,
Submission. My lord, two matters have been considered by my lords with regard to the prayer that has been sought for, saying that in service matters, PILs co-warranto cannot be issued.
2015,
Yes.
15. I have also cited judgments of the Honorable Supreme Court which says it is maintainable in education matters. Two matters I have cited. I have produced the judgment before this court, my lords. The Mohanty's matter, where the state of Orissa and another versus Mamata Mohanty, it is not qualified.
Even the post of the professor is also not a public office.
It is a public office. My lords, your lordship may kindly see the direction dated 5/8/2021.
Writ of co-warranto will be maintained.
My lord, the two matters, my lord has held there, it's not maintained.
No.
Service matters.
My lords may kindly see the direction dated 5/8/2021 of this honorable court. This honorable court heard the matter and issued directions to the UGC, University Grants Commission, that is not complied. 5/8/2021.
I'm appealing for the UGC.
UGC with impunity, they have not complied with the orders. Kindly see the order dated 5/8/2021. Till now, my lords. 5/8/2000. Can I read, my lords? Previous which directed for this one with the UGC on 5/8/2021. We direct the fourth respondent to call for records for the entire record from the second respondent concerning the appointment of the fifth respondent as associate professor made by an order dated 19th December 2017, as well as the appointment of the fifth respondent as professor made by an order dated 12th February 2020. After perusing the record and after examining the legality and validity of both appointments in the light of the amendments made in the petition, the fourth respondent will file a detailed statement of objection taking a clear stand on the controversy. We grant time to the fourth to do so till 3rd September 2021. Till now, it is not complied, my lords, by the UGC. Lords, 2018, UGC has brought in regulations regarding plagiarism, my lords. Serious view has been taken by the UGC. That is not implemented by the second respondent university as on today. The 2016 regulations is not implemented by the university as on today. My only, this one is, now, after this order, I am told the university has installed the plagiarism detection software. Let this research general of this person go and university file an affidavit regarding his, after this writ petition is filed, the 2016 regulations of UGC say that a plagiarism detection software has to be installed by the universities. In Karnataka, my lords, none of the universities have installed this plagiarism detection software. UGC guidelines of 2016 is not implemented in Karnataka in a proper manner. And this order of 5/8/2021 is violated, my lords.
But it was filed in.
Not complied with by UGC till today.
Which one?
My lords,
5/8/2021. I'm sorry, my lords.
5/8.
5/8, my lords.
my lords, in that regard, I would like to make a submission. The records have been called for. I'm appealing for the UGC. I've received instructions that the records have been called for. I beg the indulgence. I will file the counter affidavit. Prima facie, they have formed a view. I will file a counter affidavit, my lords. It's been delayed. I entered appearance only in 2024, my lords. It's the change of counsel. But I think the records have been called for. I've been informed by the relevant people in the UGC that the records have been called for and they have updated a view.
Filed, the counter is not filed.
No, my lords. I believe it's not been filed. I'll file the counter, my lords.
As on today, it is not filed. From 2021, UGC.
Let him file the counter.
They took time on
An
it.
advocate for the UGC's appears through video medium to request the court to grant time to enable him to file the counter affidavit. The time is granted, extend over to 22nd August.
Please.
Please, my lords. I'll file it at the earliest.
appearing. My lord, in this I appear
27,
for
my lord.
the government. My lord, I have filed the report.
Yes,
Yes.
Lordships may, my lord, kindly see the report filed on page number 2, my lord, of the report just now filed. This is suo motu PIL, my lord, regarding the vacancies in the health department.
Oh, she appeared from it.
Lordships may see, my lord, page 2 of the report.
She's not looking. My lord, I filed the reports here. See.
May I persuade your lord? May I persuade your lordships to see page 2 of the report, my lord, which my learned friend today filed, in which, my lord, there are about 34,967 sanctioned posts. Lordships have it, my lord. My lords may see second page. There are about 34,967 sanctioned posts, of which, my lord, 20,000 are working and 14,523 vacant posts are there. In the table itself, my lord, it is very clear. I'm just reading the summary of the report. The tabular column, the total, and of which, my lord, the most important vacancies are left without recruitment. Lordships may see, my lord, the sanctioned strength is 34,967 and working are 20,444. And also, my lord, Lordships may see we had made a specific reference to the amendment in the law at page 54, my lord, of my writ petition. We had invited, my lord, this honorable court's attention to the fact that Karnataka compulsory service by candidates completed medical courses amendment ordinance has been issued by the state. As per which, my lord, the compulsory rural service has been dispensed with. And in response to that, there is no specific, my lord, response by the state as to how they wish to, my lord, address the situation where rural service is, my lord, not compulsory today. And in place of the compulsory recruitment, compulsory rural service candidates, they had to make alternative arrangements. There is no specific response.
My lord, let him read the
My lord, I
entire
appear to
report and
respondent
make a
number 1 in
submission,
this
my lord.
matter.
Let him not go by the table. My lord, I have culled out everything, my lord, and I have informed this honorable court as to the steps that have been taken by the government.
This
My
is
lord,
not
the
an
report is.
adversarial litigation, my lord. I am only pointing out that when the compulsory rural service is being dispensed with, there should be, my lord, adequate arrangements made by the
My
state.
lord, the report is paid. My lord, in my statement of objections, my lord, I have culled out everything.
I am reading the statement only, lord, therefore. Lordships may see column number 5, my lord, in that report.
My lord, let him read the whole.
Am I audible, my lord? I'm sorry, I'm not able to see the report. Sorry, my lord, I'm not able to see the court proceedings, but the visuals. Yes. Lordships may, Lord, permit me to read page 3, the summary of the table. May I read it with your Lordships? On page 3, a reading of the column reflects that as far as the post of medical officers are concerned, the sanctioned posts are 2,355. Out of those, 1,750 are presently working in the permanent post. The remaining 605 medical officer posts are vacant. 287 posts are filled through government contract. 801 medical officers are filled through National Health Mission. And 252 more posts are working under compulsory rural service. Now they are working, my lord, but this ordinance, I think, my lord, has changed the situation. Then out of 2,877 sanctioned specialist posts, 2,133 are presently working as regular permanent doctors. 50 specialist posts are filled through government so-and-so, and 612 specialist posts are filled through National Health Mission. And remaining 82 specialists are working under compulsory rural service. Now, out of 425 dental posts, 400 are working. Now, my lord, the important portion in para 3. As far as junior laboratory technician is concerned, as against the sanction strength of 2,324, the technicians are working 1,682, leaving vacancy of 642. These are, my lord, laboratory technicians who are very important for, my lord, the contagious diseases and pandemic situation. Recruitment of 204 junior lab posts is underway, which is not done, with document verification so-and-so. And, my lord, further, Lordships may see 150 posts of resident parent cadre are under document verification process. Proposal for filling 413 posts are vacant. So, my lord, this is the prevalent situation. And my lords may see pharmacists also, 2,932 posts. The pharmacists are not only 1,729, leaving a vacancy of 1,200 at page para 5, my lord, of page 4. So as we go down, my lord, the doctors are, my lord, the sanction posts are many, but recruitments are few. But as we go down the ladder, the important positions, my lord, remain vacant. And para 6, my lord, as regards nursing officers, para 6, your lordships may see sanction post is 6,750, then 906 posts are vacant. Lordships may see para 6. And, my lord, group D employees, most important, because in PHCs, my lord, the group D employees are most important. 10,253 posts are vacant. Para 7, my lord. Group D employees, 10,253 posts are vacant. This is, my lord, the most important revelation in the report. So this, my lord, the government has to act on a war footing basis. And last time, my lord, I made a humble submission, my lord, that central government also has released funds, and they need to, my lord, whether these funds are utilized or not, also has to be, my lord, submitted before the Honorable Court by filing a response on behalf of the central government.
My lords, I appear for respondent number 1 in this matter, my lords. My lords, my submission is that public health, my lords, is a list 2 subject. Only the state has jurisdiction over this matter. My lords, the central government has no role in this matter. My lords, my humble submission is to kindly delete central government as a party. Union of India has no role. They have released the funds to the state. It is not anybody's case that Union has not released the funds. The funds have been released. The manner in which that the state has spent it, and in order to answer the petition, my lords, it's the state government alone that has to provide the answer. Therefore, my lords, my submission is that the Union of India may kindly be deleted. In fact, on the last date, the Learned Counsel for Petitioner also made this submission that Union has no role, so it may kindly be deleted, my lords. They've been misjoined in this petition.
No, if the central government, my lord, is not interested in, my lord, even disclosing how much money has been, my lord, released, at least let that be on record. And after that, my lord, it is Lordship's choice, my lord, how the matter has to be dealt with. Para 19, kindly see, my lord, the response by the state. As regards government and so, Program for National Health Mission, Ministry of Health and Family Welfare has released 792 crores to the state government, and a sum of rupees 951 added by the state government for the financial year so-and-so. Utilized sum is 1,629 crores. Now, and therefore it is submitted that a sum of rupees 8.
Sir,
This is
tomorrow-
what, my lord, the statistics say.
Sir, tomorrow it will continue.
Good.
My lord,
Grateful.
my lords kindly, serial number 55, my lord, where Rajiv Gandhi matter was argued. Lord, I'm filing the state's response, my lord. Yes, I'm just filing the state response. Written synopsis. I'm obliged, my lord.
Serial number 30 is another Suomoto, my lord, proceeding, my lord, with regard to dengue fever, my lord, which was listed on the 24th. Has been, somebody mentioned it. My lord, there is some alarming increase, my lord, in the numbers, which the government's website indicates from 24th till now, my lord, there is an increase of some 4,000 cases. The government is reporting. I did not know, my lord, the matter has been mentioned to be urged. Great.
Serial number 29. Serial number 29. The matter, my lords, pertains to the appointment.
May I request for 19th, my lord, there's another contempt petition filed by the other petitioners in the red petition, which has been listed on 37, my lord. May I request for 19th, my lord? There's another contempt petition filed by, my lord, this is a contempt petition filed, my lord. There's another contempt petitioner, 19th, my lord. There's the other matter list. 37, my lord. I'm sorry, my lords. Nineteenth, my lord. Much obliged.
Lord, 32, my lord, section 11 matter, compensation had to be fixed.
I appear, my lord, in that matter, 32.
My lords may fix an early date, my lord. We are not getting any compensation from CERC. I'm a central government.
Proceedings are already pending before the KERC, my lord. My learned friends' clients could participate.
No, that is KERC, my lord. Central Commission has to fix because I am appropriate government is.
One of the judicial members is continuing by virtue of the order passed by the Supreme Court. Now they.
My lord, I have filed the statement of objections. My lord, notification has been invited. My lord, the last date for filing applications is 8th of August. My lord, my statement I have filed, I have given an explanation.
Not on the issue of the application, I waiting the application. But the order of the Honorable Supreme Court, my lord, says that till, my lords, the vacancies are filled, not the existing judicial members to continue. That is not, my lords, is followed.
My lord, that
one judicial member is concerned, my lord, that order is insofar as one judicial.
No,
The other judicial member is, my lord.
Members. The
My lord.
specifically uses, my lords, the judicial, existing judicial members.
The other judicial member is already retired.
Directions issued to the Labour Commission are not beyond the permits of the statute because it's affecting me and the company. And it's a dispute between the employer and employee. Because directions have been issued. That's my lord. To permit some sort of a settlement between the third party and the employee in my petition. In short,
Serial number 33, my lords.
Thir-
Serial number 33, my lords.
32, my lord.
33, my lords. She's a widow lady, my lords, running post to pillar insofar as restoring her name in the revenue record, my lords. My lord, serial number 33, insofar as she is a widow lady, she is running post to pillar insofar as in restoring her name in the revenue record, my lords. In that regard, my lords, yes, my lords. Short date.
My lord, in that matter, all the revenue records are seized by the investigating officer. And initially, Lord, the husband of the petitioner has been convicted in the lower court. And they have preferred an appeal before this honorable court.
State has preferred, but subsequently same submission has made before the learned single judge and division bench and even in SLP, my lords. And
All the
SLP,
revenue
SLP,
records
my
are
lords, have
seized by
been
the
confirmed, my lords.
investigating agency. Direction is to mutate the name of the
Only that much, my lords.
petitioner.
Here, my lords,
Since the
other
revenue records are seized by the
I ma-
investigating officer.
same submission has been made, my lords. After observation of this, my lords, the direction has been issued to and decrease on her name, my lords. And they have undertaken that pursuant to the decree, my lords, her name would be entered in the revenue record. Now they're saying that, my lords, she is not, the records were written with the COD. The same submission has been made before
have
single
filed
judge
counter affidavit.
and division bench and even in a SLP. The direction issued to incorporate her name, my lords, in the revenue record. And that is the undertaking taken by the Tahshildar himself, my lords. After the decree, we will restore her name. Now they deliberately saying that, my lords, records have been seized, my lords. And in the appeal, my lords, in a criminal appeal, they have been acquitted, my lords. And he is the person no more, my lords. Now she is a widow lady running post to pillar from past 15 to 16 years, my lords. That is the
30th August.
short date,
Lord,
my lords.
serial number 32, my lord. Serial number 32, my lord, section 11 matters. Compensation has to be fixed. And also, my lord, the batch can be disposed of.
No, 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 no. It has to be heard, my lord. There's no urgency because the reason is that there's already a proceeding before the Electricity Regulatory Commission. If they
So
want.
Central Commission is the appropriate commission, my lord. The lordships have heard it. Any early date, 2:30, my lord, will.
Yes, madam. 59 years.
At 2:30, my lord, lordships can, the batch can be disposed of.
So we'll take up on 28th August, 59. 72 years.
37 appellants paid 3,700 rupees for this. According to me, it is enough. In spite of that, office has raised the objection.
We do not, that we are not solving the office objection.
32, my lord, lordships may assign a date, my lord. at-
Office evidence shall be removed within 4 weeks. Anything? Yes, mister. What you are saying?
32, my lord. The
Yes,
batch
okay.
matters relating to section 11. Matter has to be heard at 2:30, my lord, if your lordships may oblige. Because the whole batch can be disposed of, my lord.
What is
Very
it
short
again?
issue where compensation has to be fixed. Other section 11 has already been revoked. Lordships have, my lord, partly heard this matter. Any early date at 2:30, my lord, the whole batch can be disposed of. my lord.
3rd September.
Grateful. 2:30, my lord.
That we'll see on that day. Forty. 44. The fresh petition. Fresh petition. It is a fresh petition or?
No.
No. 3rd September.
No, the issue is this. I mentioned on the last date also.
What you will do on 3rd September? If you argue today, what will you do on 3rd September?
No, my lord, I will not ask a question. Because I am.
Take your time. Take your time. Sit down. Take your time. Don't be, we'll wait for you. Yes, anybody?
No, my lord, I just mentioned, I'm called upon to pay a demand of 72 crores to them on the basis of 9 quarterly installments, which fall due every quarter. And in quarter of July, they will, my lords, my apprehension is enforce that demand. I'm an auction purchaser of a lead. I challenge that demand. My prejudice is, my lords, if I'm not able to, my lords, persuade your lordships, I'm required to continuously pay them. Pleadings are complete. It's a short issue, my lords, which is why I'm requesting, my lords, any short date if it's.
2nd September. Not possible.
I'm obliged.
Court officer. Court officer. Sir, serial number 75 ಯಾವ ಡೇಟಿಗೆ ಹೋಯ್ತು? 76